Good evening. Hold on. Can you guys hear? There we go. I was wondering what the hell's going on. Good evening, chat. Hello. It's Friday night. And tonight, we're going to lead off. I guess we'll do the little story first, a little bit of a Russell Greer update. But yes, Patrick Tomlinson, his lawsuit against the Milwaukee Police Department, kind of setback in some areas. But as we talked about before, they kind of did him dirty. So I remember, like, I get it's a lawsuit and he's a lolcow, but like, this is kind of one of those times where the lolcow, even the court agrees, like, yeah, there was a lot to this. And yeah, the cops fucked up a lot, but they still dismissed it. We're going to get to, I guess, kind of addressing one of the very big problems in the U.S. legal system about what happens here. So we got a movie light. What the hell? I don't get it. But anyways, we are going to get into that. Greer in the middle of the stream, so he has to watch the whole stream. I'll bounce through it at some point. That'll be the best way to handle him. So, April's saying, oh, is he in? Oh, no. It's, yeah, Patrick Tomlinson's not a Destiny. He's different. He's different. Mr. Bowen says, wrong, stalker child. Enjoy prison. No, it is you. It is you, litigation child. Enjoy your dismissal. It is you, police abuse child. Enjoy your qualified immunity. Zaxarian, you're saying the city messed up? I don't think so. I mean, we'll get into it, but these claims, like a Manel claim, we talked about this before. Manel claims are not, and if you guys watch Civil Rights Lawyer John Bryan, like these types of things are very, very not easy areas of law to litigate. So we'll get into it. So I kind of agree with what you're saying, but not all the way. Not all the way. So, but who is Manel? Is she cute? We'll get to that, Mafka. It's good to see you, by the way. All right, guys, so let's get started. Once again, my name is Sean, also known as Potentially Criminal. I'm an attorney in the Cleveland area, and let's get started. We have some updates, first of all, in the Russell Greer lawsuit against the hardship, the Kiwi Farms. And that's how I imagine Russell says it if he wouldn't have to, if Russell, the Kiwi Farms, the Kiwi Farms, the harms from the farms. That's what Russell's talking about. There's a lot going on here. There is a very, very, very interesting update and things. But remember, last time we were here, we talked about it very shortly. Russell Greer survived the motion and dismiss, and the court denied everything. And we are now into what happened in the case. Well, they have to schedule things. They have to put something together. And we also have a big update from the Supreme Court, which it doesn't count as I would argue it's not a home run, but it's about as good a thing that could happen that we would want to happen here. That is, I guess, I hope that makes sense. Like we kind of were hoping something would happen. You're like, okay, I can deal with this. And it's pretty good. It's not perfect. It's not a home run, but it's like a triple. It's like a base clearing triple. It's not a grand slam. But you can put some runs on the board. You could put some runs on the board with this. And that's what we're looking at here. So the first things first is the case of Sony and Cox Communications, which had been already argued at oral arguments from the Supreme Court regarding basically the theory of contributory copyright infringement. And is it a valid thing? Yeah, 3 RBIs are solid. Yes, they are. Yes, they are 100% solid. And what did we see here? Well, this case came out, and remember, Cox was an ISP, an internet service provider, And Sony sued them because people were using their services to infringe and pirate songs. And even in this situation where Cox had been 98% effective in stopping people through either suspending accounts, terminating accounts, sending them emails, calling them saying, you really need to stop. We can't have you do this. They were 98% effective. Sony still sued them and got over $1 billion judgment for copyright infringement under the theory of contributory copyright infringement. Well, we heard the case. The case got heard and decided on the 25th. And this is big news, guys. This is big news. Oh, I said was an ISP. They still are. Yes. They are still an ISP. But we're not going to go all the way into this, but it's just the beginning where they discuss what actually is contributory liability here. Well, they point out at the beginning of this. Also, by the way, chat, before we get too far, Thomas delivers the opinion. Roberts, Alito, Kavanaugh, or Kagan, Gorsuch, Kavanaugh, and Barrett joined. Sotomayor concurred, and Jackson joined the concurrence. So what does that mean? It was 9-0. That's how, that's how confident the Supreme Court was. It's like 9-0, complete shutout. But what happened here? And we're going to get to this here. They point out that if you violate the exclusive copyrights, you're an infringer. Okay. Well, then there's a theory of contributory liability. And that requires a provider intended its service to be used for infringement. And you can show infringement in two different ways. First, you could show you affirmatively induced the infringement, or second, you could say you were sold a service tailored to infringement. Okay. All right. Well, those are the two basic ways, the theories you can do it. Now, how do you prove these two theories? Well, the court discusses that here, and they get into it. And they point out that, and this is the holding, and this is where if you guys want the TLDR of a court case, just start reading right there. It's literally maybe a page. But it boils it down so succinctly here. And it says the provider of a service is contributory liable only if it intended the provided service be used for infringement, which can only be shown if the party induced the infringement or the provided service is tailored to that infringement. Okay. So how do they establish things here? It does not, they point out, like, you're not expressly liable just because somebody infringed. Like, it's not an automatic, it's not what's considered strict liability. Merely the fact it happened and they used your service means you're automatically liable. All right. But they point out that there are secondary copyright liability that goes prior to the Copyright Act, but the court is loath to expand such liability beyond what's already out there, meaning they're not going to expand it more. So they're saying under this court's precedent, the intent required is if the party induced the infringement or the service is tailored to that infringement. And they're going back to the Grokster lawsuit that went to the Supreme Court. And they say you induce infringement. How? Well, you have to actively encourage infringement through specific acts. And they put it in the Grokster case. File sharing software companies promoted and marketed their software as a tool to infringe copyrights. And a service is tailored to infringement if it is not capable of substantial or commercially significant non-infringing uses. That's actually kind of important here. Because guess what? The farms isn't marketed to do infringement, and you can do a lot of other things on the farms significantly in a significant way. So it's not infringing activity. They didn't explicitly kill the theory, but the farm's activity is 100% part of this right here. I think you can easily show that. They point out, for example, they say in Sony, and notice they're already saying it's Sony. Well, this is Sony too. Yes, but Sony sued Betamax back in the day because when Betamax first came out, and remember, Betamax preceded VHS. Well, it's copyright infringement because people could sit there and copy our videos and copy the tapes. The sale of the Betamax tape recorder did not constitute infringement. And it reasoned the tape recorder was capable of substantial non-infringing uses because you could, use to record copyrighted televisions for later viewing, which would not constitute infringement, even though it could be also used to reproduce and sell copyrighted programming, which would be infringement. You could do things with it. And they also point out that mere knowledge the service will be used for infringement is insufficient. Well, there you go. And they point out here, Cox never induced its users nor provided the service. Sony provides no evidence of express promotion, marketing, or intent to promote infringement. And they point out Cox repeatedly discouraged infringement by sending warnings, suspending services, terminating accounts. In the case of the farms, Null takes things down. If it really is an issue, there are DMCA problems. And people have to put things up in a way that doesn't infringe. So once again, contributory copyright infringement still exists, but this is the standard that has to be met. This is the standard that has to be met. GM is saying Sony was Betamax. No, Sony sued Betamax. I don't think it was like whatever company was Betamax, but like Sony sued the company that made Betamax. Was it just called Betamax Corporation? But anyways, people were being sued. People were being sued because, you could use that to copy shit. Sony owned Betamax. Okay, yeah. Sorry, Disney sued Sony. Yes, sorry. Yes, I had that the wrong way around. But yes, Betamax was like, well, it works. You can watch tapes or make tapes. You can also record something at home. I could record a baseball game and watch it later. That's not infringement. Now, if I recorded the baseball game and showed it to the neighborhood, that would be infringement. They also point out that the ISP is capable of substantial or commercially significant non-infringing use, which, yes, you can use the internet for all kinds of things besides infringing on copyright. You can, you can play video games. You can read. You can watch chicks in Ukraine blow horses. You can do all kinds of things with the internet. There's a lot of Betamaxing these days. Char. Yes, and that's the point, Shinobu. Yes. If I record it myself and I just have a collection of baseball games, that's not infringement. If I record it and then use it for like showing the neighborhood, that would be infringement. That's where it starts becoming an issue. Tech Guy Sells is an interesting example. Well, it is. So ultimately, that is where we go from here. Sony won a major case, and now Sony has lost a major case in copyright. It's very much a yin and a yang thing. It's the Jungian thing, Colonel. It's like the Born to Kill slogan and the peace symbol on your helmet. It is a sick joke. So this helps the farms quite a bit. It really, really helps them, I think, at this point, because Russell has to meet that burden. And I don't, where's Russell going to get any evidence that Null was inducing it or he created the farm solely to do this or substantially do this? He doesn't have any of that. So Russell's really going to lose. Russell is really, really, really going to lose on that. So why don't you jump on and come in for the big win, soldier? Mavka says the MLB has said if I do it, if I talk to my dad on the phone about the game, it's infringing, yes. Saberplane is saying, since Sony owned Betamax, would some sort of estoppel apply? It's a very good question. Also, the F-86 Saber is never a bad choice for an airplane to have as a profile picture. Never a bad choice. No, because this is contributory copyright infringement. And I think this is arguing with a different thing. This is not a... I think it's analogous, but I can see that this was, it obviously survived this far up the road. This is more of an issue about how to handle the internet more than anything. This is the courts catching up to technology somewhat. But it becomes an issue about what do you do from here? And I think ultimately Russell's fucked. Now, what does this mean for other lawsuits out there? Ethan Klein's lawsuit against the Reddit mods, I think, is actually stronger now because they clearly were communicating their intent. Now, does Reddit isn't in trouble because Reddit could always say, well, you could do all kinds of other things besides this. But the mega thread pages that the mods put together, I think really opens up the liability for the Reddit mods even more. So the theory that you could allege for a contributory copyright infringement used to be kind of nebulous and broad. And in this case, the 10th Circuit said, yeah, Russell's claim and his initial theory might be broad and nebulous, but it's okay. Well, the Supreme Court said, no, it's now got to be narrowed. It's super narrow. But that also means it's well-defined. If you fall in that little channel, you're going to get fucking squished. So I think Russell Greer is going to, even more so now, will lose. Ethan Klein, I think his case is actually significantly strengthened from here. So we'll see what that does for him. But they're still dealing with the subpoena hell that's going on. And then there's also Denham's is seeking the opportunity to challenge the one of the counts of infringement against her on the pleadings. So they're going to have like a little summary judgment battle over one of the counts here. I don't think that's been established which one it's going to be, but they're asking the court to let them fight over half of the case without any further investigation, which is weird, but I think, Ethan's pretty confident that they'll be all right. Manny B says, I have a senior friend that flew the F-86 in Vietnam. It would have been the F-100. It would have been the Super Sabre. The F-86 was not in Vietnam. That would have been fucking oof. I mean, that would have been shoot alive by MiG-17s and MiG-19s, not to mention 21s, or imagine trying to dodge like a fucking SA-2 guideline in an F-86. Those guys wouldn't have a chance. Oh no, what happened? Hold on, Clyde. Hold on. What happened to Tiger Woods? I don't know what happened. Come here, buddy. Come here, Clyde. Come here. Come on. He's like, fuck you, fat man. Come here, buddy. Come here, Clyde. All right, well. Tiger flipped another car. Oh, I bet that's total. Oh, he got a DUI. I was about to say, single car accident's totally not a DUI. He called it the Sabre and said he was in the Air Force. Okay, well, they flew the F-100. Like, all right, well, we're plane talking right now. So there are two airplanes. So faulted by my own dog. Yeah, it happens. It happens. So there are two airplanes here that we're talking about. And then there's two airplanes. There's the F-86 Sabre. This flew during Korea. It's also the first airplane to use the AIM-9 Sidewinder to get a kill. The Taiwanese hold that trophy. And it was like 1956. They used an AIM-9 to smoke some PLA MiG-15, I think. And then there's the F-100 Super Sabre, which was a refinement of everything by North American Aviation. And yeah, it's pretty fucking slick looking. They use that for like high-speed bombing runs, and that would come screaming in and drop some napalm, like in a very dangerous cast situation that could come in like a treetop height and drop it. So, yeah. The Super Sabre looks like a spaceship from the 80s. Yeah, but this is part of the Century series of fighters, like the F-100, the 101, the 102, on up through the 106. So there was a bunch of them, but this was a workhorse in Vietnam. So, yes, the Sidewinder. The Russians also got access to the Sidewinder. They did, sadly. So, but anyways, that is sorry, Maddie, we had to address that because you guys are talking. I played Battlefield Vietnam and it was a Super Saber. Yeah, it's called the Super Saber. They didn't just call this the Saber. The F-100 is the Super Saber. After the plane talk, you autists can organize your office by color. Oh my God. You guys are just, why? You're having the chance to learn things, and I'm trying to culture some of you out there to learn about airplanes, and it's good for you. Um, so, hold on here. What was somebody saying? Amateur Iconicals talk about Saber Dance. Yes, the F-100 Super Saber had a very dangerous, flight characteristic when you were in low speed, like high angle of attack, like you're coming in to land. You would basically suffer a wing stall, and your nose would just like climb, and it was like a fatal crash. It was very, very dangerous initially. And it would kill a lot of people on landing. Very, very dangerous. They had to work on fixing it. So yeah. So, but basically, you had to land at kind of higher speed and with a lower angle of attack. I have 2 planes inside of them. They're both gay. They're both gay. All right. Okay. With all that shit out of the way, guys, we're going to move on. Basically, that's what's going on there. Now, there were some filings of other stuff that happened in the meantime in the Russell Greer suit, and we're going to get to that here. This is hold on. Do I have these in the right order? No, I do not. Okay. So since the motions to dismiss were denied, the court said basically discovery is back on the menu. And we have to get back to it. Because remember, the court stayed discovery while the case was, while the motions to dismiss were being addressed. Well, now that's done, so it's game time. And this is where things start getting fun. That things will start getting fun. And the last time we talked, Matthew Hardin had filed for a motion for a sentencing order. Or sentencing and scheduling order, not sentencing, or a scheduling order. Basically, he says, Judge, can you please get us back on track? If we're done, it's now time for us to start getting this case dealt with. Well, Russell Greer said, no, Your Honor, I own my map. We can't have this. And from here, guys, I will show you the screen. I had to block out Russell's address because remember, Russell's the moment his address, which he hasn't lived at in years, shows up, Russell, the sand and silica in Russell's vagina starts vibrating really, really fast, and it causes Russell intense pain. So we have to take care of that for him. And Matt Redson, did we get to the pepperoni? No, we're not on to Patrick Tomlinson yet. And hold on 1 second, chat, real quick. Thank you. I love you. All right, chat. So here's what happened. This is really funny how this is starting to go. Russell is starting to crack up really, really bad. So we see in the case of Russell Greer versus Joshua Connor Moon et al. And John Potter. It's so funny seeing all this. So what do we have? Here? Well, we have some stuff going on. So Russell Greer doesn't like this. And here's how it starts. Russell Greer is a human being, not a character in a game. Okay, here. I mean, You act like an NPC. This case is being litigated against a backdrop of unprecedented harassment and professional misconduct that makes a standard scheduling order impossible at this stage. Does it really, though, Russell? Does it really make it impossible? I don't know. He currently opposes the request to lift the stay on discovery or ending a scheduling order. Well, how do you have discovery if there's no scheduling order? You have to. You have to have a scheduling order because the integrity of the discovery process has been fundamentally compromised. Man, he's got ChatGPT working overtime. Also, still, please, Russell Greer, for the love of God, fix these. Fix these. Please fix your indents. But yes, he's human. He's gay. He has a mannequin face. It's the uncanny valley. Thank you. Thank you, sweetheart. Green Cap says should have put Russell Greer in the thumbnail. I thought about that, but yeah, I really wanted to focus on Patrick Tomlinson. He's the main character tonight. He says there are currently 2 pending motions to disqualify Hardin, which are going to fail. 3 motions to strike improper witness disclosures, which are going to fail. These are technicalities. They're a response to Hardin's repeated use of civil procedure to facilitate extrajudicial harassment against the plaintiff and third parties. To move into a scheduling phase while these issues remain unresolved would be to grant a license for continued abuse. It's the hardship, chat. It is so hard out here for Russell. The court must address the ethics and conduct of Matthew D. Hardin before it can dictate a timeline for discovery. Well, it has addressed them, but it will address them again, and then you're going to motion for reconsideration, and then you're going to try to appeal again, and you're going to lose. So this will never happen. Yes, abuse is abuse. Did he get evicted? Yes, he got evicted from his weird gay tranny lover thing, and then he sued to go back into the house, and then they forced him to do it, and the police forced him to leave recently. So, yeah. Kill Billy says, how much is this costing? A lot, even at a very discounted rate. It's a lot. Will they get their attorney's fees back? How are you going to get attorney's fees from this drooling fucking retard? You're never going to get money out of Russell Greer. You're going to spend money chasing him down because people like him are good at being shitbags. You're never going to get your money back from this guy. Never, ever, ever. They point out the disqualification motions. Counsel's conduct has tainted these proceedings. And Russell's like, and I know about taint. How the hell does Russell file all this garbage? He mails it in. And they said plaintiff has filed 2 motions to disqualify Hardin for a sustained and escalating pattern of misconduct. Yes, and they have been, all that stuff has been shot down. This is not zealous advocacy. It is the weaponization of the legal system to cause real-world harm. Yes, that's what this is, Russell. Yes, the legal system is a weapon, and it causes real harm. Like you're causing Josh Moon to spend tens of thousands of dollars, maybe hundreds of thousands at this point, to defend against your fucking retardation. But yes, the legal system, it is a bludgeon. You can wield massive damage with it. Yes, you're figuring out what it's for now. You wanted it used as a weapon, and now you're figuring out that it's being used against you. You don't like it. So suffer, Russell. Suffer. As detailed in the pending motions, Hardin has used the witness disclosure process to incite criminal and stigmatizing knowledge, such as tax evasion, forgery, and fraud. Yes, it's stigmatizing and criminal. Yes. 2 individuals have zero connection with a copyright case. For example, claiming a corporate CEO has knowledge of the plaintiff's IRS filings is not a legal strategy. It is a defamatory smear. Plaintiff files his taxes annually and has no history of the crimes Hardin is inventing, for the record. This conduct taints the lawsuit and renders a fair proceeding impossible under the Utah rules of professional conduct. Are you arguing that he has prejudiced the case or something, Russell? I don't get how that works. I don't know how that works. To further prove the absurdity of Hardin's disclosures, he questioned the plaintiff's citizenship status because you typed out retarded questions. Not only is questioning the citizenship status absurd, it has nothing to do with copyright. I hope you mess up and they accidentally deport you. Like, I hope one of the clerks is looking at this and goes like, yeah, we'll call up ICE. And then they show up and say, sir, are you a U.S. citizen? He go, and they deport him to fucking CCOT. That would be the best. That would be the best for Russell. They get off the airplane and they're like, what's your name? And I'll go, I don't know. As it happens to him. It's great. The 3 pending motions to strike, which are for Waylon Huber, I forget who NB is. Nicole Banks, no, what's her name? What is it? Is the Banks chick. And then SC, hammer home the human cost of Hardin's tactics. Natalie Banks. There we go, Natalie Banks. These motions represent a desperate need to protect private citizens from a lawyer who's essentially acting as a conduit for internet trolls. Oh no, Russell, no. Well, actually, if he had full facial movement, he'd be like, no. Instead, he's like, no. Targeting by association, yeah, blah, blah, blah. Waylon Huber's a fucking scumbag and helping you try to set up your little whorehouse hotel. Real world consequences, because the intent to subpoena him. Huber has been subjected to relentless harassment by the trolls. 2 farmers by the name of Ajax and Elijah Edwards criminally stalked the plaintiff and Huber through email. After harassing them, Ajax had the audacity to tell Russell that Jesus loves you. Well, Jesus does love you. Jesus loves everyone. You know, as we learned even in Fury, does Jesus love Hitler? Yes, he does. Weaponized disclosures, to put targets on the backs of private individuals. Said he will subpoena Waylon Huber. The motion to strike should be addressed. You notice it's the only, like, he mentions Natalie Banks, but then he never brings up it's a problem here. Isn't that funny how that works? He's like, it's all dangerous to them. No, Natalie Banks is dangerous to you. I forget who SC is, but whatever. South Carolina. The whole state hates Russell. The issue is ongoing. The harassment is not stopped. When the plaintiff accidentally put 10th Circuit and not 9th Circuit in the citation he used in a motion, Hardin responded with a barrage of emails demanding admissions and accusing Russell of lying about the existence of court cases. You did a lot more than that, Russell. You lied and fabricated shit. You used AI to do it. Instead of harassing plaintiff through email, Hardin could have simply Googled the case. Well, if he doesn't know where to look, yeah. And if you said something incorrect to the court, you have a duty to correct it. This pattern, taking minor procedural point, improper case citations when they're a hallucinated law is not minor procedural. That's a massive issue of lack of candor to the court, Russell. You can't fake cases. And twisting into a character attack, well, you are dishonest, you fucking worm. Confirms that Hardin will not participate in normal professional litigation. Because how do you know what normal professional litigation is, Russell? Are you going to tip your hand now that you can't use the Tard defense anymore? I don't know. Defendants like to bring up the many court cases plaintiff has filed. In all those court cases, Hardin's the only attorney to act completely unprofessionally. I'm sure that's not how you felt at the time for each one when Scortis ate your fucking lunch in the Ariana Grande shit. Like he has in this case. He's the only attorney to CC non-parties and accuse them of things that didn't happen. How do we know they didn't happen? He is the only attorney to have contacted he's the only attorney to do IRL shit. And to have nothing to do with this case simply because to act at the behest of Josh Moon and put things onto the farms that wouldn't have been otherwise put onto that site, all for the entertainment of anonymous individuals who hide like cowards behind bizarre usernames. No, you can find me. I use my name, Russell. I use mainly my account. I have like a couple burner accounts, But I have my main account. Like, you know who I am. I comment and shit as me. You can find me. But for Hardin's fishing expeditions, Huber would not have been stalked. And the scheduling orders would expand and legitimize the ambuse. The ambuse. The defendants seek to rush into a scheduling order to expand their reach. No, they want to conduct discovery. It is time to do discovery, Russell. We are at that time. There is a rhyme and a reason and a time and a season. Well, guess what? It's discovery season, Russell. If the court allows discovery to proceed now, it's telling Hardin he can continue to name irrelevant witnesses and disclose private information and trigger further harassment. If the court eventually grants the disqualification or strikes the disclosures, any discovery conducted in the interim will be fruit of a poisonous tree. No, it would not, Russell. The exclusionary rule does not apply here. I don't know if I don't think ChatGPT is that retarded. So I don't know if that's Russell or AI. But no. The abuse. No, it's ambuse. We're just gonna make shit up about Russell. He spelled it ambuse. Ambuse. Yes, we are on year 6 of this case. It is a waste of judicial resources and an unnecessary risk to the safety of the parties and non-parties. What happens when you lose, Russell? Because you're going to lose. What are you going to cry about then? So this case was stayed to serve 2 John Does, and that stay must remain because plaintiffs still cannot serve the John Does. If you can't serve them, Russell, then the case has to move on. Or it has to be dismissed for failure to include necessary parties. I mean, you're kind of making an interesting admission here. Anyways. They say the plaintiff is a real person? I hope so. Otherwise, you're a cyborg. You're an android. Are you interlinked, Russell? You see a turtle on a post. Interlinked. And to treat this case with the gravity it deserves. The gravity it deserves. There's more gravity on fucking Pluto. The legal system should not be a tool for internet trolls like you or lawyers who facilitate them. Well, you don't have a lawyer, but you are facilitating things here, Russell. They want the court to deny the motion for a scheduling order, maintain the stay, and immediately adjust pending motion, disqualify Hardin, and strike the improper disclosures. Signed, Reverend Greer, my left foot. So this is Russell's, Plattsburgh. This is Russell's Plattsburgh. Oh my God, chat. It is so funny. Isn't it so funny? Isn't it so funny? Oh my God. It's the best ever. Like, how does he do this? How does he do this? Well, yesterday, 3 things popped up. 3 things came out. And Matthew Hardin comes out the gate, chat. Because the motions to dismiss were denied, there had to be an answer. Because you challenge the motion to dismiss for various reasons before you file an answer or responsive pleading. Otherwise, you negate that ability. So Matthew Hardin did file an answer. And I love how it's just like lolcow LLCs. Lolcow's the first word on the thing here. This is his complaint. This is his answer to that complaint here. And they have to point out that, this is all a bunch of denials. Deny. All of this. They just keep on denying. Matthew Hardin keeps denying. They admit that Lolcow owns the farms. Okay. But then they come back with something interesting. Matthew Hardin punches back with a counterclaim. So basically, he looks at Russell Greer and says, not only is it you suing me, but I'm suing you. And they filed a counterclaim. They're suing Russell Greer himself for things. We're just going to touch on this briefly here. And they say this is an action from Greer's abuse of process, wrongful use of civil proceedings, and tortious interference. And they talk about the threats of police action, threats of bar complaints, and eventually ancillary litigation before another court. Remember, that's the protection orders that Russell Greer tried to get. So they're moving forward with things here, and this is just a discussion of what Russell Greer has done. And they're going after him for abusive process and other things here. James Reed, you're saying, if Russell loses, is he smart enough to file an appeal? He's not going to win on appeal. And remember, the only reason why he won on an appeal was because of the copyright troll law firm took up his case and got it litigated to the 10th Circuit. But now with the Sony ruling, that was kind of a waste of time. So no, Russell won't be able to do it on his own. And the circuit courts won't fuck around. They don't tar guard. They don't tar guard like the district court does. They are far from it. They will not put up with this shit. So they go through this. They talk about the parties here. Well, we know all the parties. Matthew D. Hardin is involved in this. Matthew Hardin is in privity with Joshua Moon and Lolcow LLC. Privity means he's engaged in privity of contract. And all legal actions taken against Hardin by Greer have been taken in an effort to deprive Josh Moon and Lolcow of their legal counsel. Hardin's not a party, but he's being identified for the purposes below. And I do love how they talk about with Russell Greer here. He's the plaintiff. According to recent filings with the Nevada Supreme Court, Russell Greer is challenging his eviction, which he's going to lose. Greer is currently residing in an automobile. He's homeless. He's a bum. So the jurisdiction's already been addressed here. We're not going to worry about the jurisdiction. We're not worried about the factual allegations because we've gone through all these factual allegations of all the abuse and all the things I've done here. But yes, the wrongful use of civil proceedings. This is a cause of action. It is a tort action. And the Utah Supreme Court has recognized this action. And they say if they act without probable cause and for a purpose other than that of securing a proper adjudication. And Russell had no probable cause or even reasonable basis for belief to initiate a civil suit against Matthew Hardin in Nevada. Russell Greer should have known that Matthew Hardin is not subject to the jurisdiction of the courts in Nevada. Russell Greer should have known that neither Lolcow LLC or Josh Moon are subject to the jurisdiction of the courts in Nevada. And they just go on. Like, everything he does here, is an abuse of the process. And that's count 2 also. Specifically, abuse of process. And the 10th Circuit recognized abuse of process is related to wrongful use of civil proceedings, but it is a distinct action. So that's why there's both of them. You'd say, well, it's the same thing. Kind of. But they point out the courts say abuse of process requires pleading and proof of 2 elements. The use of legal process is primarily to accomplish a purpose, not within the scope of the proceeding for it was designed, and malice. And I think they've met those. They've met those things against Russell Greer. And count 3 is tortious interference. Well, what was the tortious interference here? Well, it interfered with their ability to have their counsel and the avowed apparent intention of using proceedings to disrupt the adjudication of the case. By interfering with the contractual relationship between Matthew Hardin and the farms, and also Null. He gets second point there. But for a tortious interference claim, you must show the defendant intentionally interfered with the plaintiff's existing or potential economic relations by improper means. It caused injury. It's caused a lot of injury. They point out unfounded litigation is an improper means, which satisfies the second element. And they say that, the court explained because such acts are illegal or tortious in themselves, they're clearly improper. And remember, tortious means it's something actionable in civil court. If it's illegal, it's generally criminal, but a tort is a harm you do in a civil action. So if I punch you in the face, it's battery under the law, but it's also battery as a tort. And it says, intentionally filing civil actions against Matthew Hardin was meant to interfere with his representation of Josh Moon. It was meant to knock him out of the fight. And this just goes on and on and on here. So they want declaratory relief in this. And what do they want? So they want a lot to happen here. They want a declaration from the court to clear their names and reputations and allow their counsel to continuously represent them. They want a declaration of that, and they want to declare no such misconduct has occurred. Matthew Hardin is a good boy. They also want the court to declare that Greer is a vexatious litigant. Ooh, it's finally happening. It might be happening, chat. It might be. It's finally, the words are starting to appear. Because that would protect everybody from his abusive litigation tactics. And it would. If you get labeled as a vexatious litigant, just like Acerthorn, if you file actions, the court has to preview them before it allows you to file. They also specifically request a declaration that all allegations Greer has made against Hardin were truly directed at Lolcow and null. And because Hardin was acting in his capacity as counsel, no acts complained of relate to the personal conduct of Matthew Hardin. That Matthew Hardin committed no stalking of Russell Greer. And that Greer's actions were filed without probable cause. And that Russell Greer is a vexatious litigant, and he has made materially false statements of fact in that court in Nevada. And they also want the court to say, as a result of the abusive litigation practices, Russell Greer is barred from initiating proceedings against Hardin or his clients absent pre-filing for good cause. And once again, pre-filing means Russell has to submit it to the court and they preview. They read every word of his emotions and his complaints before they let him file them. They also want other things. They also want a judgment against Russell for not less than $75,000. We'll see a dime of it. Also, that Russell becomes declared vexatious, which once again probably ain't ever going to happen. Even if they want everything else, he's not going to get that. They want to enjoin Greer from filing any parallel actions against Matthew Hardin or his clients. And they want to require Russell Greer to post a bond to ensure his good behavior in future litigation before this court. Meaning, yes, chat, they would want Russell Greer to be forced to make a deposit of like $500 or $1,000 based on the idea that he would have to file that, and to keep his money at the end of the case, he would have to comply with discovery and overall control his demeanor and behavior. So it's a bonding process that he would post this money, and should he cause problems, they would take it away. They also want a jury demand. Imagine trying this shit in court. That would be awful. Mavka says, how long does a vexatious litigant label last? Forever. Forever. You're not generally going to convince a court to unvexatiously litigant you. You're a vexatious litigant for life. And that's because people who get labeled it are generally lunatics. Like crazy sovereign citizen types or Acerthorn. Do you think Acerthorn's ever going to get any better? No. The people who get it are complete nutbags. So, for example, I don't know if it's on the farms. I should look into this. The quantum grammar guy who thought like grammar was mathematical in the way he did stuff. He tried to make this like fictional postal court. He was declared a vexatious litigant, and, for years and years and years, the better part of like decades, he was a vexatious litigant. The court's never going to change their mind. Like you've kind of fucked yourself up at this point. So Haschick says, where does Russell's automobile reside? Russell probably lives somewhere in LA right now. I doubt he's got the gas to go anywhere. So, and Russell better be like, he could go live in the underground catacombs underneath Las Vegas in the sewer systems, because actually a lot of homeless people do that. Just because they don't get a lot of rain, but it's an entire like place to go live. So he'll really be like, he'll blend in down there. So from there, they point out Matthew Hardin filed a status report really quick, just 2 pages here. And they provided a court, they're providing a status on some things. Hardin was working on submitting something about the Supreme Court case, but that has not happened yet. It's not available yet. At least I didn't see on Court Listener. But he is working on it. So Russell Greer still has not provided the doc. Jeez, wow, that was like fucking Michael J. Fox arm. He has not provided the documents. Remember, he has still not provided those documents for the restraining order that were filed in Utah that he's happy to provide. Still hasn't happened. Still hasn't happened. Notice, chat, we're on document filing 457. We're on entry 457. The first time this happened, he was ordered over 150 filings ago. 150 entries ago. Russell Greer was supposed to do it, and he never did it. He never did it. It's, you know, and they says Greer's made no efforts at all to comply with the court's order granting the motion to compel. And that's going back to order number 227. So over 200 and, you know, it's that one is 230 ago. 230 filings, chat. 230 filings and docket entries in the system have processed, and he still hasn't done anything. That's a lot. That's a lot. It's just what is going on here? They also point out this court expressly warned Russell Greer that non-compliance could result in dismissal. And they cite the, filing number 300 that we'll be talking about Rule 37 sanctions in the case of termination for failure to cooperate, which could include fees, among other things. They point out while Greer has been in complete and willful noncompliance, he has 3 new suits in Nevada, one of which named the undersigned counsel as defendant and which is currently the subject of a counterclaim. There's also the case of him citing Greer versus Aguilar. He's suing the Secretary of State. There's also the Greer versus the Viatron case. And then they talk about the bullshit protection order case, Greer versus Hardin. And they point out it's a pattern of vexatious litigation, which Greer is free to perpetually seek relief against his foes, but sees himself immune from court orders entered against him. And Russell does. Oh my God, that line is straight. Wow. How did I do that? So they submit that this case should be dismissed due to plaintiff's repeated and willful noncompliance. Alternatively, this court should issue an order to Greer to show cause, where the case should not be dismissed. Well, that's not going to happen. So this case will keep going. The farms will suffer, and Russell will continue to be allowed to fuck around. So that is the total updates of everything. That is the last thing that got entered. That was today, chat, the 27th. So, that is that. That's the end of that right there. That is where we now move on to. Where the fuck did that go? I just had it open. Where did it go? Oh, hold on. There we go. That's why it didn't. Oh, so yes, the Russell case is still going. When will it end? I don't know. Don't know. But we move on to the main event tonight. The main event tonight, chat. The main event tonight, Patrick Tomlinson. Patrick Tomlinson, notorious lol cow, terminal Trump derangement syndrome patient, and just complete goober fuck of a human being. And if you've seen him on Twitter, chat, he is the man who says, enjoy prison, stalker child. So what has happened to Russell? Well, aside from taking his days and making delicious pepperoni, just, he sent me some. Tastes good. Making pepperoni out of melanated, underprivileged, and victims of colonialism in this community. Patrick Tomlinson is the subject of multiple police encounters. Guys, there's no screen to share. There's no screen to share. Like, calm down. There's no screen to share where I'm explaining things. Just shh. Have some pepperoni. It'll calm you down. It'll calm your nerves. Patrick Tomlinson is the victim of not one, not two, but tons of swattings. And remember, that's when people call the police and say, you know, there's murders at this house. Please send help immediately. The police show up with guns, and they force everybody out gunpoint. Now, in Patrick Tomlinson's case, allegedly some of these came from Tor SWATs, the swatting group that was, you know, among swatting Patrick Tomlinson, was swatting government officials at every level of government, absolutely based, including senators and members of the House of Representatives. Absolutely based, chat. Just saying. Then there's a theory that I still think hasn't been proven and I think has some credibility. Patrick Tomlinson, me, was going to somebody swatting set up himself. Well, who said that? Who said that? I don't know who said that, chat, but it's possible. It's possible. Now, as a result of all of these swattings, which included basically the police barging into his home and at times what appeared to be Fourth Amendment violations, when we went through this motion to dismiss, chat, months and months ago, I did tell you, I thought Patrick Tomlinson had an actual argument for some of these cases. They were violations of his constitutional rights. I did mention, though, qualified immunity will rear its ugly fucking head. And yeah, that's what he did. He sued these officers under a theory of deprivation of rights and civil rights violations under 42 U.S.C. 1983. He sued them, but he also sued the City of Milwaukee. He sued the City of Milwaukee under the theory of a Monell claim. And a Monell claim, Monell, is basically a theory where you allege basically like failures to train, improper training, knowledge of these failures, and instituting policies and procedures you know are bad. And basically, you're liable for the systemic violations that result of those. So Monell is what you challenge the city on, and then the officers face individual challenges. Well, we got the order back. The motions for summary judgment have come through. And real quick, before we get too far, we got to address it. Obscure Destination says Tiger Woo. I remember it's for the movie Shaft, where the guy's like, "You like Tiger Woo? I like Tiger Woo, man." Tiger for $5 says Tiger Woods got no wreck, denied urine test, caught another DUI. Well, was his wife smashing out the windows of his car again? I don't know. What do I think about Black Snape? Harry Potter's gay. Read another book. Johan Naxos for $2 says, make eugenics great again. Yes. Oh. Obscure Destinations says, we're going to go and gig some frogs. We'll finish watching in the morning. Much love to you too. Well, thank you. I'm sure 2.0 appreciates that as well. And then Useful Mistake. Good to see you for 5 subs. Let's get this party started, chat. It's time. It's time for a Clyda Woo. There's nothing better in the world than that. And I wish we could replicate it, but we can't. I don't know how to do it. Snape's the half-black prince. I don't... like. I only know Harry Potter, like I said, I only know Harry Potter from the memes. You're a wizard, Harry. I'm what? And then there's the meme of they're in the flying car and like the Thomas the Tank Engine like theme starts playing at ear rape levels. That's all I know. So then there's like the prisoner of Tajikistan or some shit. I don't really know. And I also know J.K. Rowling, wants to genocide all the trans, and it's like, okay, based. Yes, based. It's true. Yes. Sean is lucky Nicole isn't here. I know. I'm a foamer potter. Yeah, I don't know. Sean's Horcrux is a sandwich. I don't know what the fuck that is. I also know they have like the hat, and apparently the hat doesn't say slurs, but it probably should. The talking hat. I cast Avita Switchy. Oh. Hermione is now Indian. Sorry. Oh. Yes, the rings of power. Isn't it the choosing hat? I thought it was the slur hat. I don't know. Like I said, I don't watch it. I don't know. Anyways, let's get to the case. It was a motion for summary judgment, meaning you take everything you have so far in the case, you go in front of the judge and say, Judge, we want you to make a decision right now. Who's right, who's wrong. Adjudicate some of these claims. Well, here we go. And there's a lot of skipping around, chat. We are not reading through everything on this. We are not going to go through every single swatting incident. We'll get to the discussions of the officer's actions here. And that'll address a lot of it, guys. But it's because there's just so much in this case. There's only so much. But yes, it's Nikki Robinson and Patrick Tomlinson. That's his wife, because apparently she has to go first because he's cocked. He won't go first through the door. He's making his wife get listed first. I'm sure he did that. So all the trolls would leave him alone. And Patrick Tomlinson versus the City of Milwaukee, and then multiple officers. These are all police officers that are being sued in their individual capacities as well. This was a mistake. Hello to you too. Well, I think hello, yes. Didn't she take his name? I don't know. Maybe. Not sure. Adam A. Dude says Sean's on the list. Dude, you have no idea how many fucking lists I'm on at this point. I'm on all the lists. So, in January 2025, Patrick and his wife filed a second amended complaint. And it just goes through all of it. It goes through all of it here. Yes, a 42 USC 1983 claim. And then also Manel versus Department of Social Services of the City of New York. And that's just known as a Manel claim. That is how you challenge the training, and basically things were there. So what happened? Well, Patrick moved for summary judgment as to liability only with respect to a couple of the officers and a couple of the counts, not all of them. The plaintiffs also submitted a brief in support of their motion and a joint statement of facts, representing facts that aren't just disputed by neither party. The defendants filed a motion of their own in summary judgment. And basically, all the officers, all the other counts, the officers aren't listed here. They challenged on the rest of the case. So they talk about it. And ultimately, they grant the motion in part and deny it in part. But they will deny Patrick's motion for summary judgment. But they will grant the motion to restrict. And we'll get to all of that here. Now, the background, we're not going to get to all this. We're going to kind of just point out that Patrick and Nikki live in Milwaukee, Wisconsin, the pepperoni capital of the world. Do you think when they're butchering up the people they abduct to make their pepperoni, do you think it's like Laverne and Shirley, where like they all like singing in their dances, like we're gonna do it, do. Do you think like we're gonna make our dreams come true? Whack! As they chop an arm off and shove it in the grinder. Because I will say, it's just, hats off to the chef, let me tell you. I hear there's good jerky, too. Yes. Actually, we're just going to finish that up. I know Laverne and Shirley because, like, as a kid growing up, that's on, like, reruns was still on into the 90s. And then, like Nick at Night. Like, but I'm 60. Yeah. I'd rather know Laverne and Shirley than Harry Potter, let me tell you. You're out of pepperoni. I'm about to get yelled at. Yeah. Pepperoni is American, not Italian. Yes. Well, it's made in America. It was invented in America by Patrick Tomlinson. But anyway, subsequently, a group of people organized online began harassing Patrick and his wife. The couple's home, located within Milwaukee Police Department's District 1, is a duplex with an upper unit and a downstairs unit. The couple owns the entire house. Patrick Tomlinson's a landlord. He rents to people. He's part of the class. He's a class enemy. The communists of Wisconsin should not let him be free. They should go after him. That is what should happen here. I secretly enjoy milk and Pepsi. Ew. Yes, he's a slumlord. Yes, he's responsible for the common area maintenance. Yes, somebody did steal his chairs, and he has a massive threat on the farms. People have stolen his chairs, and here's the thing: the farms hates him. The Opie and Anthony forums and the Whack Pack and the Whack, like all those guys, fucking hate Patrick Tomlinson. Patrick Tomlinson has been the subject of many lawsuits. He has owned quasi, like a couple $100,000 in judgment. Patrick Tomlinson's a big fucking goober in his own right. Okay, if you guys want to go take a look for him, that is what you'll do there. Make sure Roscoe says, make sure you work in a few childs. And yes, also, I did get your postcard. Thank you so much. It's very cool to see. But is he pro-Israel? I don't know. Is Patrick Tomlinson, are you controlled by our Jewish overlords? Are you? Does the Mossad whisper into your ear too? They point out, though, the city of Milwaukee has a bunch of people here. A couple of these people are part of the tactical teams and also the SWAT teams. And it's undisputed that at all times, the defendants were acting under the color of state law. The parties further stipulate that no defendant ever obtained a warrant to seize the plaintiffs or search their home. And that's been true because in swattings, they don't go get a warrant because they're showing up and they're going to claim an exigent circumstance. But they point out that they talk about Count A, which is the day after my birthday in 2022. So many moons ago, chat. But we're going to skip through this. But there was a swatting. And at that swatting, they were swatted, and there was a report of an ongoing hostage situation. So what happened? Patrick Tomlinson got seized on his porch at gunpoint, and they searched the homes. They tried to tell him, quit showing up, don't show up anymore. They talk about then later on, there was a memo posted, saying that be careful when you go there. There will be swattings. And that this is, there were also things requesting to label it as a swatter house in the computer dispatch saying, hey, when this pops up, this might be a swatting. So everybody kind of chill out, still show up and knock on the door. You don't have to be worried. It's going to be a thing there. And this happened again and again and again and again, chat. I mean, look at all these pages of what's going on here. It just keeps going. It keeps going. Now we're on to the legal standard for summary and judgment. Moving on to summary judgment. And federal set. Now we normally talk about summary judgment or motions to dismiss under the Rule 12b-6 standard, but we're past that point. Okay. Once we get to there are no genuine disputes of material fact, not even saying we're going to take it and believe their claims are correct. No, the motion for summary judgment at Rule 56 is saying everything he says is true, Judge. Everything he says is true. We agree all the facts are correct. All the facts are correct. We agree everything happened One of us is right or wrong. You tell us. This is a very different standard. You're not presuming light most favorable. No, literally the police are saying, yes, I did that. Yes, I came to his house and pulled him out of his apartment at gunpoint. And yes, I searched his house without a warrant. I didn't break the law. That's a summary judgment thing. This is a very dangerous situation for them, for either side, because you can lose summary judgment. If I'm the plaintiff and I say, hey, defendants, I want summary judgment, and they say, okay, the court could go, actually, the defendants are right. Especially if they have a counterclaim, the judge could say, actually, their counterclaim is correct, yours is wrong, you lose, and now you're liable for damages. And you're like, problem. Also, though, you could be the plaintiff and win right off the bat and kind of save trial, save all the other things here. I mean, so hence the term summary judgment. But yes, this is Rule 56. You have to show there are no genuine dispute as any material facts in the movement's entitled judgment as a matter of law. Remember when we talked about this when we first started, there's no question that they didn't have warrants and that they were clearly operating as cops. They were clearly operating under the color of law. And like nobody's contesting a lot of the facts here. And they say it's material if it might affect the outcome of a suit. And they say ultimately, every fact and reasonable inference in light of favorable and non-moving litigants. They go through all of that here. And they point out, though, a dispute of fact is genuine if the evidence is such that a reasonable jury could return a verdict for the non-moving party. And that's where it becomes an issue. Okay, so what do you do here? Well, what's a genuine dispute? Well, could a jury find actually the cops were right or you're right? Well, were the shoes red or blue? Was the right red or green? Then it's a dispute in fact. But if everybody agrees the light was green, who had the right of way? You're kind of cutting out problems here to deal with. My name is Karen says this guy has been swatted like 47 times. Not like that many, but a shitload. Patrick Tomlinson has been swatted a shitload of times here. Okay. And ultimately, the non-movements don't need to match witness for witness nor persuade the court their case is convincing. You only have to come forward with appropriate evidence demonstrating there is a dispute of material fact. So, there are times where the party A may want to do it. So like Patrick may want to do it and the city will oppose. And they'll say, no, it's not true. Here's our difference. In this situation, though, there's a lot of agreement. Like, no, we're agreeing to a lot of facts. And they point out if on the record as a whole, a rational trier of fact cannot find for the non-moving party, you'll find for Patrick if you could not find for the police. It's a very simple standard there. It's very simple. It's very simple. Very, very simple. Now, this is where we start getting into things where I do think Patrick Tomlinson does have some claims and the court agrees. So the Fourth Amendment, you are protected against unreasonable searches and seizures of people and property. Searches and seizures are prohibited without a warrant founded on probable cause. Or if you don't have a warrant based on probable cause, you need exigent circumstances. And that involves going and searching where you see Stiegel versus the United States and Payton versus New York. Now, why are these two kind of important? And if you guys have watched me before in the past couple of months, I mentioned these two cases. Stiegel and Payton involve situations where the police have entered homes without warrants. And generally speaking, you need, even in Payton where they had an arrest warrant, unless you're chasing that person and right then and there, you generally need a warrant to get into a home. And Stiegel had also confirmed that in a third-party situation. But there is a lot there that you generally need a warrant to get into a home. And here's the situation: the cops are coming to Patrick's house. And they point out the Fourth Amendment, the home is the first among equals. It is true. And that's Florida v. Jardine. And also Payton. And remember, Payton involved going into a house. And the Fourth Amendment has a firm line drawn at your threshold. A man's home is his castle. It's sacrosanct. And homes are not just the physical structures. You also have curtilage, and that's the area immediately surrounding and associated with your home. So where does that include? Well, that can include your porch. Like if you have a porch or a front stoop, that's your curtilage. Kind of like all around the house. And like a way you could think of curtilage would be like if you have a patio, that's going to be your curtilage. Like kind of like anywhere around the house you would put garbage cans. Is the way one of my professors explained it, like is an easy way to do it. That's what you're getting into. The curtilage is relevant because, includes the front porch and the backyard. Now, does it include your whole backyard? Maybe, maybe not, but definitely would include like your patio. And if all that right there, if you have bushes around your house. My cat's name is Karen says, even if you rent, yes, because as a rentor, as the person renting, you're presumed to have license to that property. So yes, you do have that. Even if you are not a renter, but you are staying there, as long as you're like a longer term person staying at the house, you have Fourth Amendment rights as well. That's a case. I think that's Dickerson versus Minnesota. Oh, is it Dickerson versus Minnesota? Hold on. Is it Minnesota and Dickerson? I think so. No, that's the Plainfield thing. It's Minnesota. No, hold on. What is it? Damn it. Oh God. I don't remember off the top of my head. There's a Fourth Amendment case. Basically, the guy was staying kind of like longer term at someone's house. And the police raided and searched, and he wanted to challenge the search, and they said, no, you can't. And the Supreme Court said, actually, yeah, you're here long enough to do it. You have a right. If you're an overnight visitor, you generally don't have that Fourth Amendment ability. God, what's the name of that fucking case now? It's driving me up the wall. Nearnet's saying it's somewhere where you'd walk outside without shoes on is what I've heard. Well, I walk outside without shoes on all the time. But yes, it's generally right around your house. Right around your house. Where if you saw somebody in it, like they could be peeping in your windows and stuff. That's really like your curtilage. God, what's the name of that fucking case? What's the name of that fucking case here? Hold on. Yeah, let me see here. It's Minnesota versus Carter. Is it Minnesota versus Carter? I think so. Is it Minnesota versus Olson? I don't know. Sorry, chat. Well, that's part of yes. Yeah, it's Olson, I think, actually. There's Olson and Carter. I've never seen that fucking case cited before. I knew the law. I just don't know the name. I was thinking out loud, guys. It's hard to remember all this shit at times. It's hard to remember all of it. Sorry. Anyways, we'll get back to this. And they say not every interaction with the police requires a warrant or probable cause. The police can approach your house by the front door and knock. And you can wait there to be received briefly. Now, what's briefly mean? Well, in Jardines, they had to talk about this. In Jardines, the cops fucking stuck around forever. No, it's what a normal person would do. What do the Girl Scouts get to do? What does the guy selling, Kirby vacuum cleaners get to do? What does a Jehovah's Witness get to do? Maybe like a minute, I guess they're not here. I better fucking leave. I'm not wanted. You can seek consensual encounters with people at their front door. Now, what you can't do, and some of you might think is, well, I could bring a drug dog with me. Nope, you can't bring him to the front door like that. Now, that said, though, if the police knock on your front door and you open the door like a John Wick and they see bodies behind you, that's plain view. If they see your pile of fucking cocaine, that's plain view. If you go to Vito's house and there's a pile of child pornography there, that's going to be plain view. And then they could seize it. And they say that encounters like this and not a voluntary thing here are not encounters within the meaning of the Fourth Amendment. That said, if the police come to your door and they're knocking, I would not answer it. I would use your Ring camera and say, what do you want? And if they say we need to talk to you, it's like, well, let's fucking talk. But I would never open the door because you don't know what they're going to see and think they're going to see. So, like, they might think they see something in the back of your house that looks like a pile of cocaine, but instead it's actually like I was making pasta and I've got my big pile of flour and I had just made the bump in the middle for all the eggs to go in, and the cops misunderstood it. And when they came in, they got a search warrant, and then they actually found real criminal stuff. They'll be allowed to say, oopsie poopsie, we're retarded, are bad. That search is valid. So never open the door to them. You know, if they need to talk to you, tell them to fucking talk to you or tell them to give you a call. But you don't have to open the door. I would never recommend opening the door. They also talk about, you know, Terry v. Ohio, which is a little bit, you know, once again, one of those shreddings of the Fourth Amendment. But they do point out that these implied licenses are not without limits. Police can't force you to leave your home to talk to them. That's a real thing, chat, that they, like I said, they try to do. They try to say, well, we need you to come. You've seen that before in these videos. I need you to come outside and talk to me. No, I'm talking you through a screen door. No, I need you to come outside. Because once you come outside, that protection you have, poof, it's gone. Now you're vulnerable. Now they can do a lot to you. But when they tell you they want you to come outside, they're looking to fuck with you. Never do that. Never do that. You know, if you take no for an answer and instead convey a message that compliance is required, you know, it becomes an issue. That is now a seizure. Like if they're telling you if you have to come outside, and that's Florida versus Bostic. Like if, you know, becomes an issue. Like there's a lot of things that happen here. So this is a lot of stuff you guys need to understand. It's a lot of Fourth Amendment search and seizure law here. You're going to see like INS Delgado. You're going to see Terry v. Ohio here again. And then you get into situations, just basically, how do you enter a home? And yes, non-consensual entry to a home requires a warrant with probable cause. You need a warrant to get a search warrant to get into a home. And that's Kentucky versus King. And if you enter a home without a warrant, it's presumptively unreasonable and unconstitutional. But then you have to show exigent circumstances. But that's where you see like Brigham City versus Stewart, which kind of they kind of dealt with recently. There's a couple other cases they cite here, but they also cite Payton ultimately, and they go back to that. Payton was in 1981. It's a huge case in that regard. But they talk about the reasonableness requirement, and there's exigencies for that reasonableness requirement. You know, exigent circumstances, like you're in hot pursuit. You're trying to render emergency assistance to somebody. So somebody's in the house like, help, I'm dying. They're going to be allowed to go in. Or help, oh my God, he's going to kill me, help. They're allowed to go in and protect you from injury. Let's say your house is on fire and you're like, oh no, I was at a Diddy party and my hands are covered in baby oil and I can't get the doorknob. They're allowed to open that door, come in and help you. You know, there's a need to prevent the imminent destruction of evidence, which once again is such shit. Because otherwise, like other than drugs, like, you know, there's no need to do that. But they talk about cases of, you know, Michigan v. Fisher. They get down to a big one here, which is Schmerber versus California. And this was in 1966, okay? This required getting a blood draw because they wanted the guy's blood for, you know, they believed he was intoxicated in some way. Well, in 1966, there wasn't time to go get a warrant or a telephone warrant. That wasn't the standard yet. So they held him down and took his blood, and that was ruled an exigent circumstance because the blood, my illustrations are wild. Yeah, but it's funny. They've got to be that way. They've got to be that way. In order for the circumstance, okay, so Shin Abuba is saying, can the cops accidentally light your house on fire to smoke you out? That's more like a qualified immunity argument, and we'll get to that. It's very Waco-y, actually. So, which is coming up on us here in like less than a month. The anniversary of. In order for the exigent circumstances to apply, they must have both a probable cause to believe a crime has occurred or will occur, and a reasonable belief that the exigent circumstances exist. You have to have both parts of that. And they listen, like, all of this here is a great discussion if you guys want to see some things here. And they point out the Supreme Court has issued this question, some of these questions of emergency aid in a quite recent case called Case versus Montana. It was recently released. And they says an officer may enter a home without a warrant if he has an objectively reasonable basis for believing somebody's injured or threatened. But it's a very interesting case here, and they say Brigham City, and it's something that they just went through. I think it's kind of horseshit, but hey, whatever. It is what it is. Remember, the government's never going to limit their rights. Remember, they're never going to limit their rights like that. Now, we have to get to what's probable cause. Well, based on a totality of the circumstances, there's a fair probability that contraband or evidence of a crime will be found at a particular place. And that's Illinois versus Gates. This is the granddaddy of it, okay? We are past the Aguilar-Spinelli test, which was the previous one. This is the current standard in America for warrants. Now, there are some states that withhold the prior, more restrictive rules, but this is the current acceptable minimum required for a warrant in the United States is Illinois versus Gates. It's still good law. It requires a probability, not a certainty, that contraband or evidence of a crime will be found. And the level of assuredness can be described in many different ways. It's described as a fair probability. Now, think about that, chat. You have beyond a reasonable doubt. You have clear and convincing. You have, you have clear and convincing. You have preponderance of the evidence standard. Then you have probable cause, which is way down here. Not even, I'm pretty sure. It's like there's probability of it. Like, think of probable cause as being like 25, 30% sure. It's also been described as a good reason to act. Remember, think about that. 25, 30% sure something is up. You don't have to believe it more likely than not a crime has been committed. So think about those limits right there. It's made up bullshit, but it is what they've decided nowadays. I talk about if you want to search, you may draw reasonable inferences based on training and experience. And warrantless seizures operate similarly, requiring probable cause. And you can seize people under the Fourth Amendment without a warrant if you have probable cause. However, when the seizure is substantially less intrusive than an arrest, the normal cause may be displaced by a lower standard of reasonable suspicion. And reasonable suspicion requires more than a hunch, but less than probable cause and less than a preponderance of the evidence. So remember, chat, you've got beyond a reasonable doubt, clear and convincing, preponderance, probable cause, reasonable articulable suspicion. You have to believe criminal activity is afoot is the standard we're at now. So, like, here's beyond reasonable doubt, clear and convincing, preponderance, probable cause, reasonable articulable suspicion. We went from like 90% chat. We went from like 90%. We're down to like below 25% sure. It's a very low threshold. So they point out, though, that everybody agrees that reasonable suspicion doesn't apply here. But the defendants claim that this is also investigative stop territory. They don't specify the standards. But then we're also into a Terry stop issue. And a Terry stop, once again, Chad, is where the police can search you for officer safety to make sure you don't have weapons if they believe they have a reasonable suspicion that criminal activity is afoot. In Terry versus Ohio, a detective saw some guys who looked like they were getting ready to hit a joint and pull a lick. Put them up on the wall and frisked them for weapons and found weapons on them. And John Terry appealed that all the way to the United States Supreme Court. It actually happened in Cleveland, Ohio. And like there's a sign. It's funny because different things that have happened in Ohio. There's a sign for like Ohio historical facts where that store was, where the alleyway these guys got put up against by Detective McFadden. It's very interesting stuff. There is no way that worked. No, Terry v. Ohio, the officers like basically pulled out his fucking revolver and like these guys had been robbing stores in downtown Cleveland, late 60s, 66, 67, 68. Put them up on the wall. Like if you move, N-words, I'll blow you away. John Terry was black. Frisked him down for weapons for safety. Found guns and said, "What are you guys here for?" And the Supreme Court upheld that. Yes, that is 100% what happened. Now, there are issues about what about a Terry stop within someone's curtilage? Like, if you stop me and frisk me for weapons in my own property, in my curtilage, like I'm sitting on my front porch and the cops come up and they say, "Stand up, we need to frisk you. We think something's going on. Stand up, we need to check you for weapons." That's a bit of a different story than I'm just walking down the street. So, they point out that they allowed a Terry stop in a structure adjacent to a home, like a garage and a condo. A little different. In a later case, they caution that reasonable suspicion cannot justify entry into a curtilage. Another exception, like consent or knock and talk, would need to apply. Why are you going there? Well, I think a crime has been committed. Well, no, you can't do that. Eye on face says they were casing the place. Yes. They were clearly doing that. They were part of a crew that was, hitting stores and robbing people. But did he have the right to do that? So, yes, Terry is also important because the police can demand you identify yourself. Then we get into laws about whether or not they have the right to demand your identification, and that becomes an issue as well. And they say the Seventh Circuit doesn't talk about Terry stops if there's otherwise legitimately within the curtilage. There's no answer to that. If I'm already there, what happens? We don't know. We don't know here. And the court finally takes a moment to say exigent circumstances are a concept distinct from probable cause. Exigent circumstances exist where there's reasonable belief by police their safety or the safety of the public may be threatened. So they say we ask not what the police could have done, but rather what they had at the time, a reasonable belief that they needed to act and not get a search warrant. That's all it is. That is the proper way to look at it. What were they seeing, and would it have been reasonable just to do it? Now, the burden's on the government to prove that exigent circumstances exist. Remember, it's presumed to be unlawful and unreasonable unless you can prove it. And then we get to the big one, qualified immunity. The most fucking disgusting thing, and this is going to be something we're going to deal with here. The court's addressing qualified immunity. Qualified immunity protects government officials from liability for damages when their conduct does not violate clearly established statutory or constitutional rights a reasonable person would have known. And this is the problem here. To be established at the time of the challenge conduct, the rights must be sufficiently clear that every reasonable official, meaning every officer, would have understood what they're doing violates that right. But what does that mean exactly? And this is Terry versus Ohio was 1968. This is a problem. Here's the bastardization of what has made qualified immunity a mockery. There must be existing precedent that place a statutory or constitutional question beyond debate. If there is no preceding case law that says officers can't do X, then they get qualified immunity. This has been something that has been bastardized so much that let's say, for example, the police just start beating the fuck out of some guy walking down the street. You would think that that's automatically something where they wouldn't get qualified immunity for. But courts have held, well, did they know they couldn't just do that? Well, I don't think so. I don't think it was that clear. Qualified immunity. Cops have murdered people and gotten qualified immunity. And some courts have been so perverse to interpret qualified immunity as saying it's got to be that specific fact pattern has been declared beyond debate. So, for example, if a guy riding a unicycle gets beat by a couple of cops, well, if there wasn't exactly a case like that on point, then it's qualified immunity. Basically, the police get to do what I used to call, and what I still actually like to call, the John Coffey defense. The police get to throw their hands up and go, I was just some police folk, massa. I just didn't know I couldn't do that. I just didn't know I couldn't pull a gun on nobody and run up in their house without no warrant. No, sir. No, sir. I'm just simple policeman. I don't know no better. Lord and me, oh my. I just love the Constitution, Your Honor. Please don't beat me, Your Honor. Please, I'll be good. I'll be good. I just don't know no better. That's what cops turn into. That's qualified immunity. They act like John Coffey in the Green Mile. I just don't know no better, boss. I'm just simple policeman. Yeah, I'm tired, boss. I just don't know how to read them court cases. That's literally what qualified immunity is. That's literally how these cops act with qualified immunity. A qualified immunity was a doctrine invented out of whole cloth by the courts back in the 60s because the courts recognized, oh my God, people are figuring out how to engage in lawsuits. So literally the fact that the populace was learning, we could sue these fucking cops. And they immediately get qualified immunity because, oh, well, they can't defend themselves. It'll cost too much money and do things. That's what happened. That's literally why it happened. Because they're like, oh my God, we're going to get fucking sued in oblivion because I fucking smashed a guy in the face with a nightstick because he dared assert his Fifth Amendment right. Or I beat a confession out of a dude. You know, that's why qualified immunity got existed, to protect really fucking shitty police conduct. And remember that, chat. Police in the 50s and 60s and 70s, up into the 80s. Remember, Tennessee versus Garner. You could shoot fleeing fucking felons up into the 80s without question. So, yeah. Trenches and Tread says, wait, so ignorance of law is not a defense for us, but the cops can use a variation of that for their qualified immunity dickery? Yeah. Yup. Frozen A-hole says, what do you expect from unions? Well, remember, not every, a good portion of police officers aren't unionized. That was not an FOP thing back in the day. That was, the courts just, remember, there are branches of government, 3 branches of government, branches like on a tree. Do the branches on a tree ever kill each other? No. The branches on a tree grow together stronger. Something to think about. That's a Native American wisdom right there. So, T-Rex Travel says, so my question is, the crime is speeding enough to warrant a Terry stop. If the officer believes you're armed and possibly a threat, he can ask you out of the car under Pennsylvania versus Mims for his safety. And yes, at that point, he could probably Terry stop you. At that point, then you also get into like Michigan v. Long, where like the cops can like frisk a car for weapons, which is basically like your immediate area, but in a car, basically everywhere is your immediate area. That's an actual case where they frisked a car after a guy got out of it. It's a whole fucking bunch of bullshit there. Whole bunch of bullshit. But anyways, they claim the standard protects the balance between vindication of rights and government officials' effective performance of their duties, ensuring that officials can reasonably anticipate when their conduct may give rise to liability for damages. So, anyways, there's a two-part test. First, you must establish the defendant violated a constitutional right. If you fail to do so, it's over. If the right was violated, the court asks if the right was clearly established at the time in question. And then, once again, to be established, the right must be confirmed by the Supreme Court or the Seventh Circuit precedent. And that's the thing. You are limited to your circuit precedent. So most of these qualified immunity cases happen at the trial at the federal district court and then get up to your circuit courts. So that, each circuit has their own case law on these things. The Ninth Circuit obviously going to be a little more anti-police, but the 10th, the 7th, the 6th, the 5th, the 4th, the 1st, the 11th, they've all got their own circuit case laws on these things. And they also point out, once again, chat here, the cases purporting to clearly establish the right must be closely analogous to the case at issue. And some places have done that literally almost identical. So let's actually get into this. Let's get into this actual discussion of things here. So what's one of the counts? Well, one of the officers, Officer Dudley, went into the home curtilage of the backyard and began searching a cellar door. Also, they forced Patrick's wife to exit her home and entered it and searched it. They forced her out at gunpoint and then cleared the house. So they point out here, with respect to Officer Dudley, for example, they contend that leaving the home's front porch, entering the backyard, and opening the cellar constituted a search of the curtilage without a warrant. And they say Dudley had reason to know and did know the call was bogus. They're claiming that. Okay. Defendants argue that Dudley was entitled to qualified immunity. They argue it's clearly not established that an officer cannot quickly check a cellar for a suspect lying in wait when there have been reports of gunshots, even if an officer has a basis to distrust the report. Remember, this is after Patrick has already said, oh my God, I've been swatted a couple of times. If they tell you to come by, don't fucking come to my house. So the court starts off by saying it's undertaking qualified immunity. And they talk about, was there a violation occurred? Okay, and then they're going to address it here. So the court begins with whether the violation occurred. And they said, stating at the outset, it's a close call. It is. They say as an initial thing, the initial level intrusion was relatively minor. And opening a cellar door and glancing inside for seconds hardly seems like the kind of intrusion prescribed by terms under Fourth Amendment case law. And they say, and that matters, because the reasonableness of a search is balanced against the degree of intrusion. They point out the real dilemma is this. On one hand, the officer was confronted with a reliable report of a shooting, would be within your rights to check. If you thought there was somebody coming in, you'd have the right to check. On the other hand, this was not a case of a report of dubious validity, but one that was more likely than not false. So, yes, what's the objective assessment here? And they point out a reasonable officer having knowledge of multiple false reports would deem it highly unlikely a crime had actually occurred or was going on. And the comments and conduct while on scene reflect that he was not concerned the call was real, because he was he was chatting with his buddies. They were having a smoke and a joke about the dangerousness of false reports and giving no warning before opening the cellar door. They weren't like, Milwaukee police, we're going to open this door. Show us your hands. Is there anyone here? They didn't do any of that, like, as they're getting ready to search. And yes, I'm holding I'd be holding the light FBI style, or not FBI style, but the traditional way. Doing the FBI style, I don't think there really is a whole lot of incentive to that. I think this is, better. Although it's even better if you have a weapon light and you're just like on. But, identify yourself. We're here. Show us your hands, and make your presence known. They didn't do any of that. They claim he was looking for someone in wait, and they say it seems a little more than an ex post fact, like an after the fact justification, given the lack of citation, anything in the record saying why he did that. X-File style? Well, no, that was the traditional style. Silly Old Fidget says, unpopular opinion, but I feel bad for Patrick. I said it the last time at the motions for summary judgment. These cops violated his constitutional rights multiple times. Multiple times they did it. And they are going to shield themselves with qualified immunity. That's spoiler alert. Spoiler alert, chat. Qualified immunity is Deus Ex Machina. It comes in and saves the day. So, so they say, all things considered, they conclude Dudley committed a Fourth Amendment violation. They say there's limited evidence of any crime happening. The 911 report itself constituted all the evidence they had of a crime being committed. And not only did they have little reason to believe it was real, but after 5 prior calls over the span of a couple of weeks, they also had a lot of reasons to believe it was false. There was no corroborating evidence to suggest that the call had any validity. There was no screaming, no gunshots or evidence of gun violence, no visible evidence of crime or injury at all. So if the court looks at probable cause as the net weight of all information, the totality of the circumstances, the net weight here was clearly in the direction of no crime occurred, giving Dudley no reason to enter the home and open the cellar door. Even though the intrusion was minor, there was no evidence for it or reasonableness for it all. There was no probable cause. It was totally, there was, he lacked any objectively reasonable belief that it was necessary. And they say, while it's true officers have to act, it's not to speculate or meditate on whether a report is correct. They also may not close their eyes to facts that would help clarify the situation. So in short, that was justified by neither probable cause nor by reasonable belief of exigent circumstances. So accordingly, he violated the Fourth Amendment. So he did violate their constitutional rights. But remember, now we have to go to step 2. Did this in light of clearly established case law, can he know whether or not he was acting right? They say the answer here seems to be yes. And they say there's a dearth of cases addressing how officers are meant to handle repeated swatting. This alone could be enough to find that qualified immunity should apply. Because there is no beyond debate answer to whether probable cause or exigent circumstances can be found in repeated swatting cases. And they say we don't require directly on point, but existing precedent must have placed the authority or question beyond debate. And it says the court can consider whether there's a pattern of case law so sufficiently analogous he would have been on notice. And they say here the analogous cases do not confirm against the right of intrusion of this sort. Yeah, the court just goes, oh, well. Oh, well. And yeah, basically that's what qualified immunity is. It's Deus Ex Machina. Oh, it all works out in the end. Wait, all this bad shit happened. Poof, never mind. And they say, indeed, the cases provide a somewhat confusing morass of contradictory statements about whether to what extent 911 calls can be relied upon. A brief survey of relevant case law at the time of count A occurred would be helpful here. And they're pointing out it's apparently too fucking confusing for these police officers. Once again, they like to think they're professionals. They try to claim they're professionals, but they act like fucking tradesmen when they finally have to face accountability. I didn't know no better, boss. Oh, lordy me, I couldn't know not what to do. Yes, basically. My bad, ooh. Qualified ooh-nee. That's really what it is. They go, ooh, I'm sorry. I didn't mean to shoot you. Sorry. But they talk about these cases here, like this one where an ex-boyfriend said that his girlfriend was going to kill herself. Well, the police showed up and encountered a lucid and perfectly fine person. They ordered her out of the house and searched and held her on the driveway for 30 minutes. They then drove her to a hospital against her will and had her involuntarily committed. Notice what happens here. Here's what happens. The 7th Circuit condoned their actions, but condemned Guernsey's. So, one guy was like, okay, he did fine holding her in the driveway for a half hour. But, the other guy drove her to a hospital. And they said, okay, that's not too much. They said that, he should have known better. So, they point out though that the seizure was allowed. They permitted the seizure. There's another case. There's another 911 call reporting a rape and a murder. And they said where the victim could be found, identify himself by name, and gave the basis for knowledge. And the police received a false 911 call at the same address 1 week prior. It's like, well, oof. Still, they searched the house on this occasion without a warrant. The Seventh Circuit said it was a close case, and they said they permitted the warrantless entry. And they say 911 calls can be enough to support warrantless entry and, entries and searches because the caller identified himself. The court said, though, it could imagine a case in which it would be unreasonable for the officer to rely on a 911 call. Now, why are they saying the court? Because these guys weren't the same people, in 2000. It was 26 years ago. They talk about another case where that they say when somebody identifies himself, it gives a little more of it, makes it more robust. It makes it more believable and robust to rely upon it. That it's robust and tangy when that happens. They talk about another case here where the woman called a police station sounding intoxicated and threatening to kill herself. She hung up the phone when they approached her apartment, and they said they found that exigent circumstances justified them entering. And, because it wasn't clear. And that one's a little different. There was also no history of fake calls. And that one makes sense. But in this one, we've had 5 weeks. We've had weeks and weeks of it. They just keep going. They keep going and addressing this. But here we go. They point out that it's not clear. It's not clear what's going on. And they say that the takeaway is this: the Seventh Circuit and Supreme Court are clear that when there's exigent circumstances, alleged 911 calls can be enough to support a warrantless entry. However, it's unclear whether you could say it's reliable, and even less frequently what to do when the call is unreliable. There's not a whole lot here. So they're saying while the court agrees the rights were violated, it wasn't clearly established at the time of the alleged intrusion. So even though he knew that it was bullshit, there wasn't a case that says he shouldn't have done it. So he gets to go, oh, Lord, thank you, massa. I just didn't know. I'm sure he's not going to give a shit in the future either. But isn't that interesting? Now, this is I did read this when I was reading this earlier. The court made a very interesting point here. The court makes a brief, interesting thing here. A case, the United States versus Delgado, which was never cited, but gives the court pause. And they say in that one, a guy who had been shot ran into the house of someone else seeking refuge from the police, or seeking refuge from a shooter. A witness reported the shooting to the police. After the police arrived, 2 individuals came out of the apartment, one bearing the graze wound. Neither indicated in words or demeanor the shooter was in the same apartment from which they exited. There was no indication anyone else was in the apartment or that anybody had been subjected to violence inside the apartment. Nevertheless, the cops searched the apartment, later arguing the shooter could be waiting inside. Now, the Seventh Circuit rejected that by saying it's unreasonable to believe that faced with such life-threatening danger, both the shooting victim and the other guy would leave the apartment with nary a word or expression indicating that the shooter was there. And the court, that's one of the things. If your argument is so retarded, that's like the one time qualified immunity completely falls apart. But if you just say, I just don't know no better, boss, I'm just a little retard, they're going to let it go. They'll let it slide. And I really hope the John Coffey vibe came through that. Help me. I hope it worked. For the government's theory to be reasonable, one would need to believe several implausible things. And they say the government has to point to a sign of exigency. Silence cannot be that sign, as it easily could have meant a number of things having nothing to do with exigent circumstances. Although, if the police were smart, they could have argued well, maybe they were quiet because they didn't want to raise the alarm and get killed. Uh-oh. I'm just going to text. Hold on, chat. Okay, well, we'll get to that later. Yes, a retard. Yes. But they point out still, Dudley, operating on nothing but an implausible report, entered the backyard and searched the cellar, later arguing he did so in case there was a shooter. There was absolutely no indication there was a shooter in the apartment. And they point out these cases are distinguishable, though. Here, by contrast, the reports there was shooting at the home and a beating involving the residents of the home. In other words, there is reason to believe if there was a shooter, he or she could plausibly be in the home. The affirmative sign of exigency was a simple fact that the 911 report indicated an attacker in the home. So, as a second point, the court saying, look, the court found no probable cause or exigent circumstances where there exists multiple prior swatting incidences, a lack of identification or traceability of the caller, and a lack of corroboration upon arrival at the scene. It's likely not the case that a single swatting incident would be enough to eliminate this cause. Perhaps 2 false calls would not be enough. But in the case of this one here, associated with multiple previous swatting incidents, coupled with the lack of identification of the caller, call traceability, or corroborating evidence, the intrusion was prohibited. This is especially so where the act of glancing into a cellar bears little relation to the risk raised by the 911 caller, unless you're making shit up after the fact. But qualified immunity is here. So he survives on qualified immunity. The other ones, though, who went into the house and cleared it, they were both aware of the repeated swatting history at the time they took their actions. They drugged Patrick's wife out of her home and searched it. Their argument's a violation of the Fourth Amendment. They contend they seized her in light of reports of danger and violence. Moreover, they said they had, her consent to enter her house and walk through it with her. As she assented twice, opened the door, entered the home, and held the front door open for them. They argue that even if a constitutional violation occurred, qualified immunity should result. And they say, as raising qualified immunity, the court will undertake a similar analysis. And they say neither, as discussed above, neither probable cause or exigent circumstances, nor any reasonable suspicion existed to seize Patrick's wife, and a violation occurred. Once again, they had no fucking reason. The 911 call was unaccompanied by a name. The crisis line was not inconsistent with the 911 call. They reported very different situations. They were aware of the swatting history. They spoke to a decidedly coherent, Patrick's wife, who was able to explain the home swatting history. And truth aside from the 911 call, all contextual knowledge and on-scene observations belied notion of a crime or exigency. So once again, these guys had no right to do it. Defendants would have the court say it is unreasonable for an officer to believe Patrick Tomlinson, for whom there was no history of violence on record, although he had the disorderly conducts and I think he has resisting arrest, or is it just disorderly conduct? Because we listened to it the last time we went in depth, where he's screaming at them as they start arresting him, and he's like, "No, stop!" And he fucking freaks out on him. It's I thought he was gonna start dropping the N-bombs. ACOG is saying angry cop says, he acted like people, if they didn't have qualified immunity, cops would be perpetually being sued by people they arrest. I mean, yeah, okay, too fucking bad. Qualified immunity would make sure cops fucking mind their P's and Q's. Okay, you're gonna have to go to court and win. Too fucking bad. I don't care. This qualified immunity shit allows this to happen. The cops to violate their rights. So, it gets abused. People get killed over shit. Maybe cops would act a little more fucking carefully. They'd make sure their body cams are always on. They make sure that they don't, like, there's multiple people on a scene and they handle things properly. Yeah, I mean, like, yes, okay, they get sued. Too fucking bad. So do doctors. Doctors get sued all the time. They make it work. So they'll make it work. But yet there was no reason to believe anything. They say, of course, situations of domestic violence, the fact a victim says nothing is wrong doesn't immediately mean police should take that as true. And that's the case. They say there were no such affirmative indications here. So the court can't adapt that view. And they say, additionally, reasonable suspicion did not exist. There was no reason for that. But as the same reasons above, they can't conclude they didn't have reason to know that. Yes, many of the SWATs were just visits, and that's also a problem for the government. That a bunch of times it wasn't a problem, but when certain cops showed up, they acted like fucking retards, including their Sergeant Evans, the big black bull, who Patrick probably loved being manhandled by because he's gay. It's a problem, especially at that point, because a bunch of cops figured it out. Yeah, doctors accidentally, yeah. They say they just go through this. The officers ordered Robinson out of the home. They did not keep her for a long time and did not remove her from the vicinity in which they found her, comparatively not taking her to a mental hospital. And they point out here, though, it says, therefore, the court cannot confirm or right that the plaintiff seek to have vindicated. Additional cases do not shed further light on how this doubt-inducing information should be weighed as a 911 call. Turning to a search of the house, the court begins by noting no probable cause existed. So not only was the seizure illegal, the search is going to be illegal. They spoke with Patrick's wife. They saw that there were no injuries, and everything was blatantly contradicted by what happened. Oh, there's a bunch of murders. She comes out, it's like, yeah, no, everything's fine. They should have left there. It's hard to imagine how probable cause could attach. There's no question of suicidality. Instead, where an alleged assault took place following 5 false reports, and the alleged victim is visibly uninjured, you don't have probable cause. To the contrary, police had too much information beyond the calls alone to justify the search. Thus, the only way they could have been justified was by consent, which the plaintiffs argue was lacking. But the court says consent obtained after an illegal seizure is invalid unless it can be shown the consent was in fact sufficiently an act of free will. In this case, though, it doesn't sound like it. But they have to show they were free of the unlawful taint. And the court must say, is there a break in the connection between the illegality and the consent given? The government faces a heavy burden of proving that. What's the lapse of time there between the consent and the illegality, intervening factors, and the purpose and flagrancy of the official misconduct? And here, the consent occurred while she was being seized. It occurred while she was on the porch to which she had been ordered. And the court is unprepared to find that she was freely making a decision. Thus, the court finds a constitutional violation occurred, and the warrantless search lacked meaningful consent, divorcing it from the illegal seizure, meaning it was a warrantless search. Can we admit Patrick is gay? Yes, he's gay! Cops are constantly mastering their taint. Yes, they are. So the next question was the illegality of search clearly established? In some sense, yes, it's clearly established. Where there's been an illegal seizure, consent is not free from its taint. That law is beyond dispute. In another sense, however, if the illegality of the initial seizure was not clearly established, meaning, well, if you were you didn't know you couldn't seize her, it strikes a court odds to deem the right against the ensuing search clearly established. So not only, it was too retarded for you to know, but it's also too retarded for you to know your subsequent actions would be illegal too. So guess what? Qualified immunity again. Ta-da! Did you know no better? You couldn't do that, John Coffey? Did you know you couldn't murder them 2 girls? No, boss, I didn't know. Well, then you're not guilty. So if the officers would not have been on notice about the illegality, as qualified immunity requires, and consent is bound up with the illegality, the court would not expect them to know or even have reason to know the ensuing search was illegal. The purposes of qualified immunity affirm this result. Really? Like, they're too fucking stupid to know they probably shouldn't have been doing this stuff? But once again, that is the bitch of qualified immunity. So, on one hand, our rights get crushed, but on the other hand, Patrick Tomlinson is getting felted. So, I guess you win some, you lose some, huh, chat? Silver linings and all. Silver linings and all, I guess, at some point. But you have to take the good with the bad and the bad with the good. They say, though, it's, once again, you're shielding the public from rights, of which a reasonable person would have known. So, Bull Cut Nationalist says, just a simple police folk. That's literally how cops act. I didn't know no better. I just simple policeman. You give me that gun and a badge, you tell me to go enforce the law. Golly shucks, I'll enforce that law. So, there you go. There you go. So, once again, that's covered. Qualified immunity gets extended. There's another one that happens. There's another count C, March 20th. They entered and searched the home, and 2 other cops failed to intervene. They point out all 3 officers knew about the swatting history. The call came through the call did not come through 911, was made through a virtual VPN. So not even a 911 call, but it came through a VPN. And details of the call were not corroborated. Once again, the court says here, they're arguing qualified immunity, and once again, they discuss it. They point out that the analysis here is quite similar to the analysis above. If there's no warrant, how does this all work? Well, somebody claimed to be Patrick, and he had shot his mother and was demanding $50,000. It would shoot anyone who approached his home. Well, I guess it would have been more believable if it's like, I just shot everybody and I demand my book be printed by my literary agent. That would be like the funny way of having that happen here. They say by the time of the incident, Patrick had been swatted no less than 19 times. Remember, we talked about this. A bunch of times the cops just showed up and were like, knock on the door. And they went home. There was information about it. There was also an acting lieutenant had told Evans, who was a sergeant, it was a swatting address and advised him not to go inside. They say that knowledge does not give rise to probable cause or exigent circumstances. They point out, though, was it clearly established? They direct the party to the case as provided in 4.1.1. And it says they have not provided confirmation of how 911 calls are meant to be weighed. So, yeah, it's a closed case, but nonetheless, yeah, they say with no other case law providing a confirmatory statement, qualified immunity must apply. And they note that Evans, the sergeant, represents a closer call than the other guys acting above. And he still gets qualified immunity. The 2 cops who didn't stop him, well, if somebody's getting their rights infringed and they fail to prevent it, they can be liable as well. But, for an order to exist a liability, they had to know a citizen's rights are being infringed. They said, the sergeant said, all right, we got to go in. We can't wait. They didn't have the time it took for Robinson to hand the phone to Evans and for Evans to hand the phone to them to intervene. But they say baked into the failure to intervene means you have to know. There is a reason to know requirement. And here's the thing. The court just established that Evans' constitutional violation was not clearly established. Therefore, they can't be held to account for knowing. Once again, Like, think about all this. This is getting a little fucking ridiculous. Count E, they talk about April 12th. Similar shit happens again. And once again, they point out they did not have probable cause to believe a crime occurred nor exited circumstances. By this point, over 24 times swattings had happened. You know, there was a report a man had shot his wife, but the passerbys reported no gunshots. And they ended up talking to Patrick's wife through the Ring camera. They later admitted he knew there wasn't an emergency under deposition. It's like, whoa. Think about that shit. Think about that. Think about that. You know, there was no reason to believe the crime had occurred. In light of these facts, they exceeded their license and illegally seized the woman. You know, they tried to kick down her door. And it's not commonsensical to believe that after 24 calls, that Patrick Tomlinson finally became the violent person who all the prank calls were meant to be. And it says, although the violation is clear, the law was not clear at the time of the violation. Once again, going back to all the cases cited, you know, once again, they couldn't know. They couldn't know. They can't be expected to know that they should have left the curtilage when consent was revoked, nor can they be expected to know their brief seizure was unlawful. So once again, the court will consider, you know, the plaintiffs don't raise a meaningfully develop a failure to intervene claim. So they're going to the court will consider the claim abandoned and therefore dismiss it. There's another one that happens, you know, a couple days later. This one happened, what day here? Hold on. April 12th. This one occurs April 17th, so 5 days later. Once again, he forced them to answer the door. He threatened to kick it down. You know, and he demanded to see Nikki because they argue, you know, they claim Patrick was trying to kill her. They argue that Patrick Tomlinson started an argument of his own free will. They also argue that his wife merely assumed she had to make an appearance and therefore did so. Well, that's obviously not what happened. And they point out that going through all of this, for the qualified immunity, they go straight to that. They go straight to what happened here. And they say they agree that Evans violated the license to seek a consensual encounter after Patrick told him to leave. You know, at that point, there's an issue. But when Tomlin said, go the fuck away, the implicit license to remain was over. They have to go. But people have the right to revoke consent to be on a property. And the Fourth Amendment context is well established in that regard. You can revoke consent to a search. If you allow somebody to start searching, you could say, nope, consent revoked. So, now, obviously, cops don't have to act unreasonably by failing to halt their search every time a consenting suspect equivocates. But here, you know, like, I don't know, but saying clearly go the fuck away was unequivocal. So if you have the general right to revoke it and you must leave, the only question was, under the facts alleged, you know, as they presented probable cause and exigent circumstances. Well, again, the court doesn't find that either of them existed. This was at least the 30th swatting of the home. 30 swattings, chat. 30! It's like Hartman in Full Metal Jacket. 4 inches from your chest pile. 4 fucking inches. 30 swattings. Evans had been instructed not to go into the home again. The 911 reported that a man had been killed. His wife had killed his wife and was going to kill his child. But it does not appear from the record that any kids lived in the home. A home Evans had been in multiple times before and knew very well. Dispatch noted 3 times the call was a swatting risk. It was unreasonable for Evans to believe that overstaying his home was justified by risk of harm. The constitutional violation occurred, But once again, was it clearly established? Well, again, the court cannot say yes with the weight of cases involved. They call it a confusing morass, which is bullshit. So ultimately, though, the court is not convinced any imminent safety could have occurred. This law was simply not confirmed. So from here, the second argument, the legal seizure occurred. Well, once again, they're going to go under the circumstances presented. The court concludes there was no seizure in what they describe as Evans forcing Robinson to show herself at the door. Why? Well, his wife stated, I think in this one I heard Patrick yelling at him or something, and I just figured I had to make an appearance. So she voluntarily did that. When Robinson came to the stairwell, she assumed that Patrick was arguing with someone from the MPD, but it wasn't sure it was the police at the door. I'm sure when he's like, please leave, Ree! Go away, Ree! Yeah. Ion Face says, nobody's been to my house 30 times. Yeah, well, yeah. You know, the fact that Evans told Tomlinson that he would not leave until the wife showed herself is irrelevant because the wife wasn't aware of the exchange. If she had known, they could argue it was a seizure because she's being forced. But for a seizure to exist, it must be the purported compliance must occur in response to authority. That's Brendan v. California, and that is a pretty. Once again, guys, there's a whole list of these, like knowing all these, how you're seized, when you're seized. That's a whole subject of the Fourth Amendment. There's an entire progeny of case law from that. In Sibrin versus New York, they said where an officer tells somebody to come outside, they can't determine whether a seizure had occurred because there was no indication of a show of force or a submission to do that, which leaves you with no choice. Or did you go voluntarily in the spirit of cooperation? And they're claiming it was more like cooperation rather than response, which, because it's not a violation, no qualified immunity necessary. Once again, they don't develop a meaningful failure to intervene claim aside from saying it. Because they don't really flesh it out, it's dismissed. So, Bald Eagle says this court's full of cuck judges. Yeah, well, Bald Eagle, this is probably the outcome in every fucking district or every circuit in America. Just keep that in mind. This is probably going to happen everywhere. Now they point out the defendant's motions for summary judgment. So the defendants move for summary judgment on all counts as to all defendants. So they talk about count A. There's other officers involved. Remember, there was a whole list, but not every officer was being Patrick moved to summary judgment. But the cops are like, oh, no. We're running everybody. We're running the whole motherfucking thing. So the court goes through this ultimately. In any event, the defendants claim they're all entitled to qualified immunity. So they go through all this here, and they claim, they claim that some of these guys, no constitutional violations occurred. The cop who opened the cellar didn't say he was going to do it. So how do you intervene? You have to know what's going to happen here. He had no reason to think he would open the cellar door. And then, even then, if he doesn't know opening, even if he was told that, if the other guy's allowed to do it because it's not clear, once again, how is it not? If it's not clear to them, it's not clear to him, therefore no violation. So once again, Hernandez committed no violation, so the court doesn't need to give him qualified immunity. To the extent that they seek to hold him accountable for not telling him to leave the backyard when he did, once again, it's not been established to do that. So once again, no qualified. Yeah. Who's Patrick Tomlinson? He's a goober science fiction writer who's a big cuck. He hates Trump, and he's just in general a big fucking asshole. So that's why nobody feels bad for him. They talk about these other cops, and they say the court finds that any factual dispute to what they heard is not ultimately relevant. They've already explained, even if they did commit a violation, it wasn't clearly established at the time. So, this is here. So even if they had heard of the plan to search the home, they would not have been expected to stop it. So there you go. Dirty Eric says, no one you care about. Yeah. Yes. That right there, though, that right there, you have no idea. That's such a massive fucking narcissistic injury for Patrick Tomlinson that you're like, who? That's more injurious than anything else. That would be more injurious than anything else. So there you go. And they go back through other things here. As they say, as a brief reminder, the tactical officers responded to a call, and the caller reported they killed their wife with a shotgun, and they said there was already previous warnings of stuff here. Someone reported over radio there was a history of swatting, and upon arrival, they approached his wife, who was home alone, to come out with their hands up. Thereafter, they searched the house while the other guys remained on the porch. They all claim they get qualified immunity. They raise the issue about whether these guys saw the CAD notes, the computer-aided dispatch notes. But the court moves on here. The court moves on to do this. And they say, as to the initial seizures, what was done here? And they say, the court infers the officers knew about the house's history. Because remember, these guys are moving for summary judgment, so they can assume the facts are favorable to Patrick. And they're going to presume the facts are favorable. They're going to infer the officers did look at this. They were aware of the CAD. They would have approached the house armed with far more knowledge than the police normally have. Knowledge that there was something, unless there's something corroborated it was likely another swatting. But the court is not prepared to find not prepared to find no violation occurred. As to the search, it's prepared to find a violation regardless of whether the officers knew the swatting history. When they arrived, the report was of a wife shot by her husband. When the wife exited the home, well, then what the fuck's going on? And they said that ultimately they were backed up by her unarmed appearance. Your mental stability is fine. And she told the officers about the swatting history while speaking to them. And by the time of the actual search, these guys knew of the swatting history. It put them in the same position as the other defendants who were being unconstitutional. So they say this history made it even more unlikely that there was a shooter or person in the home. And they say there is an emergency aid doctrine, but whether police had reasonably believed they had to enter the home to render aid. So the officers would have had to assume the shooter shot someone other than his wife, but lied and reported they shot his wife, or the officer allowed her to come out of the house but still planned to shoot her, such that the police needed to go in. But the court's like, yeah, none of that makes any fucking sense at all. This doesn't work. You can't use it. It's not a principle they're prepared to adopt. So thus, in the absence of probable cause, the court finds a constitutional violation. But still, the court can't say it was clearly established. So qualified immunity goes. As such, the court is constrained, and this is the court saying, I wish I didn't have to, but I have to give you qualified immunity. This is the interesting part. The court says it's constrained, and that's the court applying the law. But the judge is acknowledging, I don't want to fucking do this because I think you're probably entitled to it. But he can't award it. He cannot award it. By extension, the court has to dismiss the failure to intervene claims for the same reasons. They talk about by the forced swatting call of, and that's the thing, the forced swatting call of the day on April 11th. So by April 11th, 4 times in that day, the house got swatted. The plaintiffs had been swatted 26 times. A bunch of other officers responded. Someone claiming to be a teenager had texted a suicide hotline saying they had killed their parents and were going to kill themselves. But no, notice 3 other times that day. They spoke to Patrick and his wife through the door and insisted that she show herself. She came downstairs while the officers stood around. She said no one was shot. Patrick then arrived, yelled at the officers, and was briefly detained. This is what we have the recording of this. He acts like a complete fucking lunatic. They argue summary judgment's appropriate because they argue it was limited seizure. They critique Robinson's lack of cooperation with the officers, but ultimately their argument seems to hinge on the fact that Patrick's wife was never put in handcuffs or removed from the scene. So ultimately, we get to like what happens again. All right. Well, when the court infers the knowledge of all of this here, a jury could find a constitutional violation ultimately occurred. But ultimately, once again, as discussed, the law surrounding emergency reports was not clearly established at the time. So even if they knew, it would not have been established. By extension, these guys can't be held liable for failure to intervene. So once again, they didn't know no better. They didn't know no better. Now the Manel claims, chat. This is where it becomes important. Manel claims are unique because they point out here's what Manel liability is a little different than other tort liability for employees. A municipality cannot be held liable under Section 1983 based on the theory of respondeat superior or vicarious liability. Respondeat superior is the theory you are responsible for your employees. It's a traditional term. It's a traditional tort theory. Your agents and the people working on your behalf, you are liable for them if they're doing stuff in your behest and your benefit. Now, they point out that a city can only be held liable under 1983 for constitutional violations caused by the municipality itself through policy or custom. And it says you may be directly liable when the city evinces a deliberate indifference to rights by the plaintiff by failing to train its officers or to prevent the violation. There can be no liability for failure to train when there's been no violation of constitutional rights. Am I liable for the Jannies? No. And they say as the failure to implement policy or procedure, the court has said, in situations that call for procedures, rules, or regulations, the failure to make the policy itself may be actionable. So let's say a city didn't have a policy on illegal searches and seizures, and they had no, under their manual, it said search warrants and nothing was written. That could be a Manel issue. That can entirely be an issue. That can entirely be an issue here. Yes, Manel claims are not generally a standalone count. They're an additional theory of liability. So, but that said, though, apparently everybody is treating this as standalone. So, you know what the court's like? You guys are treating it this way. I'm going to adopt the structure this way. And they say when the rules or regulations are required to remedy a potentially dangerous practice, the failure is also actionable. And more importantly, municipalities do not enjoy absolute or qualified immunity from 1983 lawsuits. So cities themselves don't get absolute immunity, sovereign immunity like that, or qualified immunity. They don't magically get that. Now, here's the thing. The defendant's argument is considered very cursory, meaning very basic. They don't really elaborate on it. Because there were no violations, they argue the claims must fail. It's a very shitty argument. It's very cursory, not well fleshed out, not really put a lot behind. So here's what Patrick and them are claiming, though. ultimately, they point out that they made their plight known to the top level people in the police department. The city's policies or lack of training and supervision and discipline could have caused a violation without the person being also liable. And part of it is, for example, Sergeant Evans, he was told, don't go in the house. Was he ever disciplined? A failure to discipline is a Manel issue. They started getting swattings. Were these cops ever trained and educated on swattings and how that happens at this point? That's a very real issue that hasn't been addressed. They also argue that the defendants was so of a cursory argument, it should be dismissed, if not forfeited and waived. Because if you just go, nuh-uh, yeah, you're going to lose that argument. Hold on, chat. I'm getting the sniffles, chat. It's sniffle season. The defendants later clarified they only seek summary judgment to the extent the court finds no violations occurred. So the court's only task for summary judgment is to determine whether violations have occurred or if there's a genuine dispute of material fact. Well, there's a bit of an issue. We already know violations have occurred. So, yeah. So they point out that, yes, unconstitutional searches were committed. They point out none of the violations were clearly established. So there's QI. And they go through all of this here. They list out all these claims. But notice, this chart is basically explaining where each claim stands. So each one of the individual officers, qualified immunity, lack of constitutional violations. Okay. But a lot of these, failure to intervene, the Manel claim is dismissed. For the guy doing an illegal search, the Manel claim survives. For these guys, search and seizure were illegal, the Manel claim survives. A bunch of these officers dismissed on qualified immunity, dismissed on QI, dismissed for lack of violation. The Manel claims got dismissed for a couple of these dudes. A couple of them, the Manel claim survives. And a couple of them, the Manel claim survives for searches and seizures. And this goes on again, qualified immunity, lack of violations. One of these guys, the search, the Manel claim survives. Once again, qualified immunity, dismissed for lack of violations, qualified immunity, dismissed for lack of qualified immunity, abandoned, therefore it's dismissed. Dismissed because of qualified immunity, lack of violations, abandoned. But you see a bunch of these things survive. The seizure survives. The failure to intervene, once again, they don't know better. The exceeding the implicit scope of what you're doing there, your claim survives. Failure to intervene, dismissed. Another case where it survives, but then the other causes of action got dismissed. This is the way it shakes out, chat, ultimately. Say it says, buy a HEPA filter. I mean, it dropped like almost 50 degrees since yesterday. So I'm thinking there's a little more to it than that. They talk about the motion to restrict. There's a joint motion to restrict participants only certain documents, namely a bunch of exhibits to the joint statement of facts. They request the court grant this because counsel's aware that the harassing group has been monitoring the docket to search for additional information they can use to contact individuals in this case. Meaning the farms is what they're arguing, but it's the internet as a whole, chat. Everybody. In addition, the harasser group has used the docket to collect information and generate fake social media profiles where they pose as individuals involved in the case. And they say some of the documents sought to be restricted contain personal identifiers. Yeah, well, that's going to be true. Show the internal structure of the Milwaukee police and how the department responds to training calls, which could be dangerous to someone who wants to SWAT in Milwaukee. So yes, what they're worried about their chat is called TTPs, tactics, techniques, and procedures. So if you understand how the police do it, it can be an issue. It's not allergies. I'm upset the pepperoni's gone. And it says the court may restrict public access for good cause. Here, the court finds good cause. And it says, for the conclusions above, the defendant's summary judgment for all the cops is granted. The court will dismiss all individual claims that counts A, B, C, D, E, and F. All such individual claims are dismissed on qualified immunity grounds, except for the failure to intervenes, which are dismissed for lack of constitutional things here being established. The court will, by extension, dismiss the Monell claims to the extent they operate with respect to the failure to intervene or with the alleged seizure of Patrick's wife in count F. Court will grant the motion to restrict. So the motion for summary judgment is denied. Ultimately, the summary judgment for all these individual officers is granted. And they talk about a bunch of Monell claims being removed, but it's denied to the Monell claims not identified above. Remember, a bunch of them survived. And they also point out the defendant claims found in count A are hereby dismissed on qualified immunity grounds, except for the failure intervention, which is dismissed for lack of violations. They're talking about the other Monell claims that are out here and how these all get sorted out. But all the individual claims, chat, are gone. Qualified immunity rears its head. Rears its ugly fucking head. So all the officers are hereby dismissed from this action. But the City of Milwaukee keeps going with the Monell claims. Not Burnell claims. No, they didn't snort hard enough. So the Monell claims survive. And honestly, chat, think about it. The court's acknowledging these cops fucked up. But hey, they didn't know they couldn't do that necessarily explicitly. They may have realized they probably shouldn't have done that. But because there was no court saying, do not do that, they get to plea the retard defense. So, as much as we want to sit here and laugh and say, ha, 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 Patrick got felted. In a way, we all got felted because these cops can keep doing shit like this and they're not being held accountable. And will the City of Milwaukee be held accountable? I don't know. I don't know. How much will they be held accountable for either? I mean, is Patrick going to get hood rich off this? Maybe. Maybe he gets $1. We don't know. We don't know. Oh. Yeah, but it's a felting that felts us too. Because if you happen to be in a similar situation in Milwaukee, these guys are going to fuck with anybody. So, yeah. Yeah, I mean, like I said, as much as everybody wants to go, felted, it's like, bruh, it's your rights too. So, yeah. Kind of like a Steve Urkel defense, kind of. You could call it that. EDW Raptor for $2 says, my Horcrux is a sandwich. Once again, I don't understand that. Blade 2.0 says for $5. I'm only saying this to say hi to Useful Mistake. All your streams are really good too. I guess I only watch all of them. Hi, Clyde. Well, I could get Clyde. Tech Guy Sal says, but today is your birthday. No, it's not. Useful Mistake says Patrick is anti-war in Iran, so I guess that might be considered anti-Israel. Well, I'm not a big fan of Iran ultimately for the policy considerations and just what this might do. I mean, I think it's based that the U.S. military apparently is like playing on fucking cheat mode. But other than that, I'm not necessarily thrilled with it. So, yeah. He's an anti-Trump rather than an anti-Israel. Well, that too. Yes. If Trump started liking Palestine, Patrick Tomlinson would get mad. Shino Boo Boo says, so you're saying the cops can accidentally light your house on fire to smoke you out? I mean, the cops have like wrongfully murdered people and they still get qualified immunity. So, I mean, it wouldn't surprise me. Yeah. They'd be like, I didn't know I couldn't do that. Bald Eagle says, Dudley ever tell the local PD that, hey, I may have some assholes constantly calling in bullshit on me? You may want to ignore it or call me if things are good. Yeah, Patrick Tomlinson told them that repeatedly. Like, don't come to my fucking house. Leave us alone. Bald Eagle 1787 is saying, what is sad is that even if a district court did start to chip away at QI, SCOTUS will just say no and smack down any challenge to QI. Yeah, it'll never go away. It'll never go away unless Congress abolishes it as a claim. Mo Greenglasses says, I was never arrested, child. Very funny. Very, very, very funny. You're so funny, chat. The Horcrux was an object in which a dark wizard or witch had hidden a detached fragment of his or her soul in order to become immortal. Eric says, what's wrong with the cheat code? I don't think there's anything wrong with that. I just don't know if this is why is this used in military force? Is this going to turn into a situation where how bad is this going to deplete military resources? Just what are the secondary and tertiary effects of this? And that's my concern at this point. And that's been not clearly established that this is all okay. That said, though, I love watching the military put foot to ass because it's like watching the A-team. Like, what's not to love? Oh, shit. I didn't have that on mute. Sorry, guys. Sorry. So. I had a giant melon, yeah. Can you play the clip where it's every time Patrick said child to a troll who was fucking with them? I think chat needs to hear that. I think we did, but it's been a long time. I don't have it on me. Sorry. Maybe I need to do that for the next Patrick Tomlinson stream. Let's be ready for that. I don't know. So what does that mean? It's going to trial. It's set for June 8th. But the attorney for the city is like, I'm having a kid. Can we please reset it? So the court's going to go ahead and reset the trial date to sometime later in the future. But Patrick will have his trial date. Stalker Child will go to trial sometime coming up here in sometime in 2026, most likely. I doubt the court's going to let this drag on forever because that's just not good for business. So, that is kind of the thing there. T-Rex Travel says, did you have time this week to do the work on that model through the looking glass you could do on stream? The model through the looking glass. I don't know. I don't know what you're talking about, T-Rex. Sorry. Oh, no. Let me see here. Okay, I see that. Okay, here we go. Well, this is Patrick Tomlinson. This is how fucking cringy he is. Patrick, this is like he says this. He calls everybody child. It's so fucking cringe if you guys haven't heard this before. So, oh, I needed the magnifying glass. Said it was too fiddly. It wouldn't work with the camera. Oh, for the photo etch parts for the elephant. Yes, I'm going to work on that on my own. Sorry, I didn't know what you meant, but yeah, I need to work on that. Maybe I'll do some of that tomorrow. I got to work on a crash appeal that I kind of got to ask, like, how soon can you do it? And I'm like, well, pay me a lot. So we'll see. Maybe we'll do that tomorrow night. We'll see, chat. Anyways, here we go.
Yes, child. No, child.
Bankruptcy.
Baby child. Baby child.
Idiot.
Little infant. Baby child. Baby infant. Stupid. Child.
And remember, the pepperoni is because he is has been widely alleged to abduct black people and grind them up into pepperoni.
Little one child.
Stop being obsessed with Twitter.
Little baby child. Baby child.
Fucking
Sweetheart.
bullshit.
Child. Baby girl.
Go-
Child.
You did- you're-
Sweetheart. Baby child.
Yeah.
Little
Yeah.
baby child.
Yeah.
No child.
Yeah.
No.
Yeah.
Yeah. Shut your fucking mouth, you stupid little baby infant.
Yeah.
Anyway,
You actually
I'm
did.
going to enjoy what happens to you next.
There you go. That's Patrick Tomlinson telling people child. That way he isn't racist, yes. Yes, don't forget about the pepperoni. No, it's not a cheese pizza thing. It's disturbing. Yes, it is. It was cheese pizza until Patrick Tomlinson started making pepperoni. Yeah. Without Patrick Tomlinson, there'd be no pepperonis. Ion Face says, yikes. Yeah, that's true. He talks like a latently gay 50s villain. Well, there's two. No mayonnaise says, they have pink eye. No, that's the Michael Jordan crying eyes. That's a meme. That's like a meta meme where they cut out the crying Michael Jordan eyes and they put them on people. It's not cheese pizza. It's obviously pepperoni. Yes, Malcolm is correct. Yes, melanated children. Yes. It's black children that he specifically grinds up into pepperoni. Now, I'm betting he doesn't mind strapping young, buff, young black teenagers to do that, teenage males to do it too. But still, it's all going in the grinder. Oh. Will there be a TTS voice for the wedding? No, we're not doing that. No. We're not out of our fucking minds. I mean, if we're going to do a TTS voice, I'd use the voices Ralph has for Power Chat. Because those are funny. The Trump voice and Mr. Medicare, all those voices are hilarious. So that's what, I'd use a lot of stuff. We'd make a great chat. It'd be beautiful. But we're not doing that. Because they're not going to have, in the middle of reading, our vows to each other, and. We're not doing that. We're not doing that. We're not doing that. And so, you can call me no mayo. My mother called me no mayonnaise. Stalker pepperoni's made of people. The teenagers make for a nice aged product. Well, yeah. The Medicare smoker hack reading the vows. That would be funny. That would be funny. The Dr. Phil voice is fun. Yeah, it is. Job well done says, yes. Job well done for $5 says, and. That'd be worried about where people are just going, hon. Wait. Listen to TTS voice doing it. Oh, we're not doing that. We're not doing that. So, but yeah, that's it for us, chat. We are all caught up. Once again, I know you might not like Patrick Tomlinson, but holy shit, he got fucking shafted by the way the cops treated him. You guys, like I said, you don't have to like him but goddamn, this is fucked up. This is absolutely fucked up. So, something to think about. So, but with that said, chat, I will see you guys tomorrow, and it's just going to be NF. Oh, wait, is that it, Pepsi Man? Pepsi Man's actually, I love our cops. Apparently Pepsi Man actually wants to tell us, Pepsi Man wants to address,
yeah. Thanks to Let's Go. We love our
cops, our law enforcement. They abuse Patrick. It's so important. We love our cops, our law enforcement. They abuse Patrick. It's so important.
And when I'm in the jam, when I'm jam. I know that I can call up the man, with a plan. When I'm on the run,
if you guys like the screen, what do you want to like? That's
all I gotta do is dial
911.
We love the cops, law enforcement.
They make Patrick cry. It's so important.
We love the cops, law enforcement. We love the military, they're important. And when I'm in a jam, I know that I can call up the man, with the plan. When I'm on the run, all I gotta do is dial 911. We love our cops,
Our law enforcement. They make Patrick cry. It's so important.
We love our cops, our law enforcement. We love our veterans, they're important. And when they're out at war,
they make Patrick Tomlinson suffer. They're so important. Yes, if you really want him to suffer, there you go. Yeah, I'm not really caring about Patrick as much as the cops are like out of fucking control. So, I mean, it's glad it happened to him versus other people who are probably not fucking assholes. But it's still, these cops will be doing this to other people. Are you gonna get copyright struck? No, you don't get copyright struck for that, Katie. No, only you did that to me. Only you did that to me. BLT says, what a throwback to a happier time. Yes. A different time, a different America, chat. A different time, a different America. You know. But instead of that, we are now into this America.
Yo, you see that nigga sweater vest? Oh shit! What the fuck? Nah, that's pretty fresh, dog. I'm a what?
That's what we're at now instead. Instead, we moved on from we love our cops to white ass nibbas going hard as fuck. That is true. That is true. Yes. White boy summer. That's right. Oh, that's right. Oh, yes. White boy summer. That's right. Get your pit vipers on, chat. It do be like that, Mr. Stansel. It do be like that. All right, guys. No, we will probably get to working on the Elephant / Ferdinand tomorrow night. I'm gonna relax tonight. It's already 11 and hot grandma summer. Well, sure. With that, guys, I will see you later. And please remember, until next time, chat, just because you did it doesn't mean you're guilty. And it's very appropriate here. Just because you violate someone's constitutional rights doesn't mean you're going to be held accountable for them. So, good night, chat, and take care. Make sure I got everything. Yep, I did. Oh.
weapons, blacksmithing, and models of planes. Going hard in these streets. Esoteric works and even some trains. Much merriment had while drinking White Claws. Tips on hunting and even talking the law.
Jim Cox says, whatevs. For 25 months. Thank you for being here that long. Thank you so much. Whatevs. Whatever.
Whatever you do, just don't talk to cops. Even when they nab you on illegal stops. Just cause you did it doesn't mean you're guilty. But
EDW Raptor for 31 months. Thank you for being here that long. Says last.
Please talk to a local attorney. Was that the fat guy that Kaden yelled at? Why, yes, it was. He even knows.
Demon's Wrath for 14 months. Thank you for being here. It says Ian is gay.
Knows he's fat for all this
Lone Alaskan's been a member for 19 months. Thank you. Says last. But we also have Amon Rez Uwu. It's been a member for 23 months. Says, shout out to all my niggas. Chef Clyde, 69. He's such a good boy. Look at him. He's got his little hat on. He's so cute. He's such a good boy. I love this dog to death. Even though he blows us off and he won't come jump in my lap half the time. He's such a good boy. He's such a good boy, and he looks so cute. Member for 10 months. Thank you, Bubba. I love you, Bubba Bear. Torgo the White's been a member for 29 months. It says, I'm last, bitch, tax-free. Also, no models tonight? No, not tonight. Guys, I kind of need to relax a little. It's been a long week. And then this user is 404, has been a member for 2 months. It says, lastest last. Thank you. I am a Iconoclast member for 27 months. Says last. Stephen Cooper for $2 says middle last. Johan Naxos with a super sticker for $149. Thank you. Edward Scott's been a member for 1 month. Thank you. EDW Raptor says for $2, last backwards. Chitin says been a member for 4 months. Black! I mean pepperoni. Oh. Jim Cox gifting 1 sub. Mr. Hutto for 24 months says Safa. Super Wiener's been a member for 25 months. That's a lot of rigidity right there. 25 months. Says 6 to last or some shit, man. I don't know. Well, thank you. Derna for $2 says you might not be last, but you could be next. Johan for 1 sub. EDW Raptor for 1 sub. Oh. Peter Keys for 2 New Zealand dollaries. Says now you can't. Yeah. Oh. Yes, we're to that awkward stage of a Bronx Tale now. We're at that awkward stage, chat. Yes, we're at that awkward stage of a Bronx Tale where, we're at that stage where,
Now you can't leave.
Now you can't leave. Now you can't leave. Lone Alaskan for $2 says first. SB Sellers for $1 sub. Katie for $1.99 says we own you. Stephen Cooper says first. Amateur Iconoclast says this is the stream that will not end. Spudgun for £2 sterling. The King Sterling says me first, might. Kite for $2 says Safa. EDW Raptor says, what does Terry Schiavo have to do with Terry Stops? Dirty Eric for $2 says sloppy thirds.